just let me know.
I believe we're back up now.
Seems like it takes a couple of minutes just to warm up YouTube. Maybe it's actually built with tubes.
Should we see if, I got a message that Anne was trying to join. Christine, do you know anything further about that? Is she?
Well, she still can't join, and I had her try from her cell phone, and she still can't get on. So she's going to drive over from Leota. So she'll be joining me probably in 25 minutes or so.
Okay.
Well, I think we'll go ahead. And do we have Brian in the waiting room?
He is in the waiting room. I'm ready to bring him in if you guys are.
Anybody got anything else before we start that?
No.
All right, I'm just going to construct this meeting the same way we've done before, where I'll ask him to do a little introductory comment or two, and then turn you loose.
I'll bring Mr. Sherwood in.
Good morning, Mr. Sherwood. Can you hear us okay? Hear me at least okay?
I can hear you.
Okay, and you are coming through fine. We have 10 members of the commission present. One will not be present at all today. We have another one who's having technical trouble, but will join us when she can. That's Ann Wiles. What I'd like to do with you and with all the other interviewers, the applicants, I should say, is give you a chance here just to introduce yourself to the commission. And when you're done, we'll open it up for questions. We've allowed 45 minutes. We can go longer if we want to. We can, if we're done sooner, then we'll conclude. But anyway, why don't you start, Mr. Sherwood, by introducing yourself to the commission.
Thank you very much. I wanted to introduce myself. My name is Brian Sherwood. Good morning to everybody. And I wanted to thank everybody on the nominating commission for giving me an opportunity to speak to you in this process. As I said, most of you may already know me. I'm Brian Sherwood. I've been a resident here in Finney County since 1990. I've worked with the Finney County Attorney's Office here since 1990. I've been here for under 3 different county attorneys. I started out with Rick Lennar Pierce, and then John Wheeler, and then Susan Richmeyer. And during that period of time, I've been pretty much an assistant Finney County attorney. I've handled numerous cases here in Finney County in criminal court, from all types of cases, from first-degree murder, rape cases, cases involving children, domestic violence, drug cases, misdemeanor and traffic offenses, juvenile offender cases, SINC cases, child needed care cases, care and treatment cases. I've also done numerous search warrants. I've done inquisitions. I've done 60-1507 ineffective assistance of counsel hearings and habeas corpus actions, and some civil forfeiture. So I've had some of that experience includes some civil practice, but mainly and primarily it's been my practice to be an assistant Finney County attorney here in Garden City, in Finney County. As I stated, I have done quite a bit of cases here. I also have done quite an extensive appellate practice. I've done well over 100 appellate briefs. I've argued before the Supreme Court, Kansas Supreme Court, and the Court of Appeals, Kansas Court of Appeals. Written numerous motions, and interacted with the public, the police, and the different attorneys that I've had to deal with. Taken cases from the very beginning, from the start, from charging cases all the way up to the time for a preliminary hearing or a pretrial, including voir dire and then a jury trial, voir dire, and then the process of the jury trial, and then also any post-trial work that includes. So I've done quite a bit of extensive practice in the courtroom. I have a lot of experience in litigation experience. During this period of time, I've had the opportunity to do all types of cases, as I stated. I've experienced the changes in the law. There's a lot of different changes that occurred in 1990. I started way back when, before the Kansas Sentencing Guidelines Act even was enacted. And then when that changed, obviously, there's been quite a bit of changes in the law. I've experienced some of that. One example is dealing with cases, insanity cases, going to mental disease and defect. I've handled those type of cases. And I've handled, when DNA was brand new and it's been developed over the period of time. I've been here during that period of time. So those are just some examples of what I've done here in Finney County. So I've had a pretty extensive background, as I said, here working with the courts, working with the judges here, and working actually in the courtroom. And as I stated, I've done quite a bit of appellate practice. Numerous times I've had to write appellate briefs, and that's my general background. And certainly, I would encourage, if you folks had any questions with me, I know most of you are familiar with me, but for the ones that are not, thank you for being here and giving me an opportunity to give you a little introduction about myself.
All right, thanks. Questions from the commission?
Yeah, Brian, one of the, I guess, in your background, you've always been in public service prosecuting. One of the things that district judges are called on to do is determine attorneys' fees in certain cases, and the district court is presumed to be an expert on fees. Do you think that your limitation in that area would impact your ability to be an expert on fees, or how would you go about getting up to speed on what's appropriate in that area?
Well, I think I have the experience and the practice that I've been able to do a lot of research and writing. Obviously, I've had a very strong practice in criminal law, but when it comes to the civil side, I would be willing to get up to speed as fast as I could, take legal education courses as necessary. I think my abilities to, as I said, research and write and do the things I've done in the past is a strength for me. So that is something that I think I could easily be able to get up to speed, understand it, and get to the point where the issues of attorney fees, in particular to your question, that I could be able to address that. I don't doubt my abilities in doing that. I have confidence that I would be able to do that, and I would be able to get up to that. And certainly, there were colleagues there that would, if something I didn't know or I need to go to, I wouldn't have a problem asking them questions. Vice versa, if they had, obviously, I have a strength and they needed to ask me questions about certain thing, I would be willing to help as well. So I think that my background, 31 years, does give me the ability to go forward and to get into areas even that I may not have touched as much as other people have, but I am confident that I can do so.
And then to follow up, you talked about the change in the law on insanity defenses. Recently, we had a change in the law on expert testimony, the admissibility of expert testimony from the Frye test of Daubert. Have you had much experience with Daubert, and how do you think that experience would help you as a district judge?
Well, I had to deal with Frye initially, and then Daubert. When we went to our prosecutor seminar, that was an emphasis at some point in time. I've dealt with it in a couple of cases. I haven't got into it, but I am familiar with that to know that the changes are there and that what we have to work with is much different than what we had regarding Fry. So yes, I have handled it. It hasn't come up as recently, but yes, I believe that I would be ready to handle that.
Brian, as far as setting criminal bonds, I don't do much criminal work at all. I do have friendships and acquaintances with other attorneys in the bar that do quite a bit of it. And there have been remarks about some inconsistencies in setting bond. What criteria would you follow in establishing a proper bond for criminal defendant?
Well, the statute is the first place you have to go to, and you have to follow the statute regarding bonds. But things that you would have to look at is this person going to be likely to appear? Is there a danger to the community in regards to the type of case or what's going on? So you have to look at the dangers possibly to the community. You have to weigh those circumstances, and you have to make your decision based upon what the facts are and what the law is. So there's a different criterias, different reasons why defense attorneys ask for a lower bond or that we need to set bond. But if it's a property crime or something that a lower level drug case or misdemeanor, it may not necessarily require that you have a cash corporate surety bond. But the other cases where you may have domestic violence, or you may have a crime against a person or a child, you may have to evaluate that in a much different light. So you're going to have to look at those factors, what the case is and what the arguments are. And obviously you want to make sure that that person comes to court. You want to make sure that that person will be here for court and respond instead of failing to appear and having a bench warrant or a bond forfeiture. That doesn't really help the system. So hopefully that's something that would be my criteria, is to look at in each individual case by its circumstances, unique circumstances, set it according to what we have before me and make that decision.
To follow up on probation matters, I've had clients in my family law practice that have talked about so-and-so is on probation. There's been 2 or 3 different probation violations. Probation officer desires to have that taken up by the court. What kind of criteria do you look at in determining whether or not to revoke somebody's probation or parole?
Well, you would have to decide your case on an individual basis to the unique characteristics and the facts of that case. But dealing with criminal cases, you have to follow the statute. We have a graduated sanction scheme here in Kansas that requires us to go through a quick dip. Depending on when the person was arrested or convicted, you may have to do an 128 or 180 day sanction, or you may have to determine what the law is regarding that particular case at that time. So you have to look at the probation violations, how extensive they are. Is this person amenable to probation? Is this person likely to continue to be reformed or rehabilitated in terms of that probation? There may be times where the person may be progressing in a way, but just isn't quite doing what that person's supposed to. So maybe as a judge, you make that decision. Well, maybe this person deserves to get some kind of treatment and address that issue. On the other hand, if somebody is just a flagrant person that abuses the probation and doesn't seem to want to follow any conditions, then I think obviously those are the type of people that just are not amenable to probation and would have to be, that consideration by the court would be whether or not to revoke that person. So it would just have to be depending on the severity level of the violations, how many violations there are, and some rehabilitation issues that may come into play for a particular defendant.
Thank you. You're muted.
Lucy, you're mute.
Brian, you referred to danger to the community in how you would go about setting bonds.
Correct.
Okay. Different judges seem to interpret that in different ways. When you refer to danger to the community, are you talking about the community at large? Are you talking about specific individuals like victims and witnesses?
Well, I think obviously if there's a particular victim or a particular issue dealing with a particular victim, you have to take that into consideration, and that may be a danger to that person. A danger to the community, I'm just giving you an example, a person is going around shooting, doing drive-by shootings, that may be a person that's a danger to the community as a whole. So you have to kind of look at the facts and the circumstances. So I think that it's important to look at that. I think that obviously person crimes are something you have to look at and see. Obviously, those are issues that a court or a judge is going to have to decide whether it's a danger to community or to a victim. And there may be circumstances that don't necessarily require a higher bond for a particular victim, but it all depends on the particular facts of each case.
So would you consider imposing less restrictive means like terms and conditions of bonds rather than defaulting to danger to the community?
Yes, that's certainly, the statute provides for that as well. And if those are certain things that can be done, there's maybe a EMD or house arrest, or maybe there's a reporting requirement, or maybe there's a treatment that person needs immediately. Yes, those are all factors I think a judge should consider. I didn't mean to exclude any of those, but those are obviously things that that could be considered by a judge, and I would certainly consider them as well.
In the course of your 31 years as a prosecutor, you've had the opportunity to review plenty of search warrants. What is your position regarding no-knock warrants, and how frequently do you advise against presenting a search warrant because you think, have you ever advised against presenting a search warrant because you didn't think there was probable cause there?
Yes, on numerous occasions, I've had the occasion to do search warrants. I've been approached by law enforcement. I have on occasion told them, no, you don't have enough. We're not taking this to a judge. I've had the ability to work with the law enforcement. I certainly believe that they respect me, and or whatever agency that I've dealt with. And certainly I've had the ability to tell them, no, there's not enough here for this search warrant. And in regards to a no knock, I would evaluate that, but I will also follow the law, whether that is required or is not required. Certainly that I would tend not to want to do a no knock unless there was circumstances provided to me, and provided that the law is changing on that, and then there may not be the ability to do no knock warrants, but I certainly would evaluate each case and each facts in making that decision.
Okay.
Brian, what changes would you like to see in the judicial system in Kansas?
Well, I've been here since 1990, and I remember coming in as a young lawyer that we had, I remember remnants of a bench and bar committee. And I think that that would be one thing that I'd like to see reestablished or brought back, because we've got a lot of different issues coming up, more immediate issues, obviously COVID, technology. And I think that a bench and bar committee, my understanding, it was helpful. The bar here is connected, and I think they would be well receptive for a bench and bar committee in terms of getting together and between the people that practice in the courtroom, the judges, and help looking at things that may improve the way we present our cases or we interact with the public. So I think that's one thing I'd like to try to do, or at least be part of. Obviously, there has been talk in the past year about drug court. I know a couple of judges have tried to do that and entertain that, and that's certainly, there's certain things that need to go forward on that. And so I certainly think that might be an improvement, or at least something that might help. I as a prosecutor, I've been doing this for 31 years, and it seems like it never fails that we get somebody and they bond out, they're back out here, they're back in court, 2 or 3 weeks on the same charge. Maybe it'd be helpful that we can get some kind of drug court. Certainly, I know that it was explored, and I certainly would like to pick back up on at least look at that possibility. So those are two things that I would like to see to improve. Obviously, we've got issues with COVID and issues with the courthouse. And as I said, I think that's why communication between the bar and the judges would probably needed more now than ever. Obviously, assist in any way that I can. I would assist in any way that I could to help formulate any local rules and just one added feature on the bench and bar committee, you could also help bring in some continuing legal education. I know a lot of us, it seems we have a lot of continuing legal education outside our judicial district. Maybe we could bring something or sponsor something in that regard. So that would be another thing to help this 25th Judicial District and all the counties. And we wouldn't just necessarily have to be in Fannin County. We could go to the other counties, and then that's important. So when I say bench and bar committee, I would like to, obviously I'm including all the counties in the 25th Judicial District.
Hey, Brian, can you just briefly explain what is drug court?
Drug court? Well, it's an intensive, focus on a defendant that has drug issues that you need to bring them back to court, and you have to monitor what they're doing. When we have somebody come to court, they may have an appearance and we may not see them for maybe a month or two. Drug court's a little more intensive in terms of them coming back and checking their progress and seeing where they are in terms of that. I have not actually done drug court. Obviously, I've taught their prosecutors across the state have done that, and other courts and other judges have done that. I know it's very intensive in terms of bringing the person back and making sure that that person is following whatever treatment program they're doing. And if they relapse, then they'll have to deal with the issues of their probation being revoked. But it's a way to hopefully get them into a place where they may, some of these counties have halfway houses where they need to go to certain places or some treatment facility. And that's something that may be helpful here to Garden City, or at least in the 25th Judicial District. So it is something to look at, and I think that's something we should try to explore.
With I'm going to switch gears. You obviously have a terrific handle on criminal procedure, criminal law.
Sure.
Complex civil litigation. Do you have any experience in that area at all?
No, I do not. The experience I've had but in the criminal law, I've also had numerous complex cases that I've had to deal with, like, for example, accident reconstruction. So there are some similarities in some aspects, but in terms of my ability to understand the law and the civil practice, I certainly would be willing, and understand that my focus would have to be to get to educate myself as quickly as possible, or go back to the principles that I need to go to and understand what it is in those complex cases. I don't doubt my ability to do that. I've been able to do a lot of complex cases in the past when criminal law. I certainly would be able to do that. As I mentioned, I would be able to reach out, go to get continuing legal education, continue, and some people have done those certain things. I would not be afraid to ask for help, or at least ask for guidance. So while I have not had that practice in those types of areas, I certainly don't doubt my ability to be able to get into it and learn it, understand those concepts, and be able to apply the law and the facts under those circumstances.
Thank you.
So Brian, when you talk about how you would educate yourself to handle those kinds of cases, the fact of the matter is, if you were selected by the governor, you may come onto the bench and end up in a complex oil and gas case or a class action or something, that is immediate and involves civil procedure and other things that you've never dealt with in the courtroom. Why should the governor select somebody with no experience in that kind of law over somebody that has practiced a variety of cases and would be ready to handle that case right off the bat?
Well, I think you have to look and judge the person that you're. I would hope that the governor would judge the person and their ability to educate themselves, to be intelligent, how they've done in the courtroom. There are times when people aren't going to have the experience in certain areas, but they're able to get to the point where they understand the law, spend the extra time that's necessary, be able to, they have the ability because they've handled complex situations. So certainly, and the same thing could be said for somebody who's never done criminal. They would also have to go through the same process, be able to educate themselves, be able to get in a situation where they're going to be able to understand it. But they may have that ability to do it because they've handled complex cases and they have the ability to research and write and apply the legal principles and deal with that. I find out no different that in my situation, I can do the same. I've been here 31 years. I think courtroom experience has a lot to do with it. And my courtroom experience is, well, I've been here 31 years and I primarily focused being a litigator in the court. So I don't doubt my abilities to be able to get in there, and even if there is complex cases. Obviously, I'm going to have to spend more time on those areas, and I obviously intend to do so, and will do so immediately. That would be a focus as a judge that I would, whatever things I haven't done in the past or haven't done as much, that's the first focus I would do, is to do what I need to do as a judge to be fair and impartial, and to be able to understand the law and get to this point where I understand. So as I stated, I still think people that may have done something more than others are still have the ability to be a good judge in all areas, whether it's civil or criminal.
So Brian, this is at least the third time that you've interviewed for a judicial position. What steps have you taken since you first thought of this career move to educate yourself and prepare in those directions?
Well, I've done some CLE. I've continued to practice and continued to look in areas that I've dealt. I've looked at some civil forfeiture cases. I'm still primarily working, with the county attorney's office, so I'm primarily focused with that. I have, obviously, I need to do a lot more, and I will, I certainly will do so.
Brian, I'd like to know how you see yourself philosophically or just demeanor wise changing over time. Or do you think you are different?
Well, I think I have. I think,
Give
well,
me a couple instances in areas where you see a different you at 30 plus in versus the guy in the first 5.
I think that when you first come out of law school, you may be a little gung ho. You may be ready to go, and under circumstances of a particular case you've come across, you've been able to understand the situation, the person that's coming before the court, understand the particular cases that you're dealing with. I think my experience when dealing with is a big factor. When you first come out, you don't have that experience, but when you as time goes by and you have a situation where you need to be a little more flexible, I think that with your experience, I've done that. So I don't, when you first come out, somebody have described me when I came out of law school as, very determined or tough-minded. I'm still tough-minded, but I think my ability to listen to the attorneys that talk to me has improved. And I think that's a good skill that I've done over the years, is because I'm going to listen. When you're out, you just want to go in there and you want to try to win the case. But now I listen to people, and they have, what I've learned over the time and period is that sometimes defense attorneys do have information that you don't have, and you need to know. And if you get into a position where they're willing to share with you, then this is a situation that we might be able to resolve the case. So I think my ability to communicate with the defense attorneys or the attorneys I deal with has improved. So I think my listening skills have certainly improved, and I try to respond to them as quickly as possible. I listen to them, what they have to say, and I won't dismiss what they have to say. They may have very valid points. And when I was young, I might not have done that. For 31 years now, I think I'm doing that on a regular basis.
Good.
Brian, I'd like to ask you about victim statements and the structure for victim statements. If you were king of the forest, how would those victim statements be presented in your court? Because, from a defense standpoint, it's awfully tough to sit there with your client and listen to the victim who's just been given a green light and just go off for as long as they want to about what a terrible person your client is. And is there a better way to do that? Is there a more structured way to do that, understanding that the victim has constitutional rights in this state to do what they're doing, to state their opinion? Have you thought about that at all? Is there a way to structure that would be more fair to both sides, do you think?
John, honestly, I haven't thought about that, but that's something to think about. But I think the victim has a right to say, I don't, it's not evidence, but it's a statement that's made. Obviously, there'd be areas where if a victim's making a statement that they go too far, I would take that into consideration and either not allow it or you might have to put them on the stand in a different way if they're making some allegations that aren't relevant to what we're dealing with. One thing is trying to keep the victim on focus on what the case is. There have been victim statements done in writing, so if that may be something. While the court has to consider it, it's not the final answer to the evidence that's presented. I think the court has to look to the evidence presented during the case, during the trial, or during the sentencing phase. So that's certainly something that a trial court would have to do. So certainly to make it fair to both sides, I think is important. And certainly if there's a better way, I would look at it and see if there is a better way.
Back in 2009, when your hair was darker, you made a presentation to the DUI commission,
Right.
and your application says that you made a presentation on regional issues. What were those regional issues that you presented to the commission?
Well, the one thing that we had to deal with out here, at least as a prosecutor, we had to deal with issues out here is mainly interpreters. And we had to deal with the issues whether interpreters are being provided and how that's going about. So that was an issue that I tried to explain to them. We're dealing with a lot more different cultures out here that trying to understand what DUI or an implied consent or whatever they need to go through. So those are things that the eastern side of the state didn't quite understand as much as we went through it all the time. We had issues that dealt with some communities had law enforcement that couldn't get back within 2 hours. That was an issue about the time. As a prosecutor, we were talking about how hard it was for an officer to get back here, because and that's why they expanded, at least considered expanding it from 2 hours to 3 hours on a 0.08, theory of a DUI. So those are different things. We dealt with issues about all different types of issues. What they asked me to do is come out and testify about what's happening in Western Kansas. What is it that you're going through regarding DUIs, and what issues are popping up when the commission was trying to entertain everything. And way back when we were considering whether to forfeiture cars, impound cars, those were issues that we had to go through. Those are just small, minor issues, but they wanted to see and try to understand what it was like to be a prosecutor or a law enforcement officer at the time out here in Western Kansas. So they asked me to come out, and I spoke to them, kind of explained to them what our agencies, what they had to go through and what they and what other issues. But one of the main issues is that they didn't have to do with interpreters like we did, whether it be in court or outside the court. So those are big things that I wanted to point out, at least during that time, during the DUI commission.
Did the commission make any recommendations as a result of your testimony?
Not necessarily. I think it was, I think they took a couple of different prosecutors from the state. They wanted to get a perspective. I don't think they necessarily took any recommendations from me, but they wanted to hear, they just wanted to hear the background of or the different places here in Finney County, or I mean, in the state of Kansas, sorry.
The status of the law on implied consent advisories is that the police do not have to provide interpreters. They just have to give them the form and read it to them in English. I take it from what you said that you would be an advocate of requiring interpretation.
Well, I think one thing that, some agencies have done it, but if they had a Spanish form, they could give a Spanish form to the Spanish speaking. In some of that respect, I've encouraged, at least sometimes during this course, I said, you need to come up with, same thing with Miranda. When they started out with Miranda, they had the English form, but they came out and started using some Spanish or some other, I think at one time they had a Vietnamese one, Miranda. So, if something could be done to assist those people, and making sure that they understand it, that's what I was trying to try to hopefully get these agencies to focus on it, that they need a chance to look at what's there and be able to read and understand just like anybody else. So some took that they listened to me, I guess, and some chose to continue the practice, they did. But that was certainly a suggestion that I was trying to make out here, is that if we dealt with that and the person couldn't understand English, that would be helpful if we had those things.
I don't want to throw you a curveball, but if you can verbalize, what do you think you bring or would bring to this job that would be absolutely unique? Something, what do you feel that you would bring to the job that no one else can bring? You're not comparing yourself to the other applicants or anything like this. Just what would you bring to this job that you feel like nobody else could bring?
Well, that's a tough question. I guess I'm going to focus on myself here a little bit. I think that my motivation, I think I'm willing to bring a perspective. Obviously, I've been a prosecutor for quite some time, but I think I have the ability to understand that you have to make decisions as a judge. And coming from this side of the fence, I've had that ability to tell the law enforcement if they didn't have enough on a search warrant. So I have the ability to deal that I think that I've done with police departments of different agencies. I think I've had the experience. I think my experience helps out quite a bit because I have that perspective that as a judge that sometimes you need to be fair and impartial, and you need to be able to make tough decisions. You need to be able to stand up even when there's a decision that's unpopular and you have to make it. I have had that experience having to do that during the course. So I think I bring that experience. I probably had to do it maybe more than other times, than other people at other times, because in 31 years, you had to tell different agencies they weren't doing what they didn't do what they were supposed to. So I think I've had that unique experience. I'm certainly motivated to be a judge, and I think I have good ideas. I certainly would like to. I think I could bring to this particular judicial district, like I said, the bench and bar. I think that would be. I'd like to be a little more proactive in terms of trying to getting people and the practitioners and the court together. So I think I have that. That's what I'd like to do. So I think everybody has good qualities. I think that I would be a good judge because I've had quite a bit of litigation experience, and I've been in court. I know other people have that, but I've been doing it for 31 years. Come across that experience. My emphasis was that I bring a lot of experience that I've done in the courtroom, and I think that would be it'd be unique. I mean, 31 years doing what I'm doing and how I've been doing it, I think is a plus.
Brian, in business litigation matters that would come before you, what would your policy on alternative dispute?
Brian, you talk.
I'm sorry.
What would your policy on business litigation that comes before you? What would your policy on alternative dispute resolution be?
Well, obviously that's an option that could be explored. I know that mediation's been done and different alternatives have been done. Certainly, that would be something that I think could be considered. And if a case needs that, I certainly think that would be appropriate. So I'm not opposed to it. I think it would be appropriate.
We have any other questions?
Brian, you talked about Miranda and in the context of answering your questions or the questions regarding implied consent. Do you have concerns that that implied consent carries some of the same constitutional considerations that custodial interrogations do?
In some respects, yes. You know, I think there needs to be a fairness in terms of what those persons understand. They're going to lose, you know, their ability to drive or their ability to do what they're doing. The law hasn't changed on that yet. So, but I would follow whatever the law is what it is. But it, you know, it is somewhat of a concern making sure somebody understands what they're going through. And certainly as a prosecutor, I've tried to make sure, or at least try to encourage law enforcement to, you know, trying to have them understand, have the people that they're dealing with understand. So yeah, I think, I don't know, you know, that's certainly a concern.
Anyone else? Well, hearing nothing, Brian, would you like to sum up before we close out your interview?
Sure. Once again, thank you, each and every one of you, for giving me an opportunity to speak to you. And I appreciate the questions. They were all important questions. I do believe that this community needs people to step up and need people in this community to be somebody with experience in terms of, we need a judge that has experience. And I certainly believe that I have the experience. Nobody's perfect. I believe that obviously I have a strength in one area, and I certainly believe in my abilities to be able to handle the other issues. And I certainly believe that I've done extensive appellate research and writing practice as a prosecutor here. I've dealt with numerous issues dealing with cases and complex issues. So I certainly I don't doubt my ability to be able to do the civil cases and to be able to understand the law and apply the facts. And certainly I would want to be a fair and impartial judge. I would like to be open-minded. I would like to be a patient judge. I want to be a firm judge when it needs to be. And I also want to be a judge where it needs kindness and compassion. That's when it needs to be. I want to be able to be a judge that understands how the law and the facts apply to each human being that comes before this court. As part of my practice, or at least part of my experience in Finney County, going back to Rob's question, I believe that I have learned quite a bit from being a young person or young attorney right out of law school till now. And I've been able to understand the human beings or the people in this community in 25th Judicial District. And it may be totally different than other places, but I've been here 31 years. And I've certainly been committed to, as a public servant here in the county attorney's office under three different county attorneys. I certainly would like to continue to practice. I'd like to be a judge to help this community. I'd like to bring other ideas to this community. I'd like to get the bench and bar committee and get everybody working in a good direction. As I stated, I certainly believe in all my abilities and my experience, and I do appreciate each and every one of your questions. And thank you for your time here today.
Well, thank you, Brian. With that, we'll conclude this interview. And Shelby, when you're ready, you can bring in Mr. Marquez. And Ann, I see you've joined us.
Okay, I will go ahead and bring in Mr. Marquez.
Can everyone hear me?
Yes,
Okay, great.
I lost you for a second, Mr. Marquez, because you jumped to a different part of my screen and I was staring in a blank spot. So I apologize for that. I'm Dan Biles from the Kansas Supreme Court. I'm the non-voting facilitator for the 25th Judicial Nominating Commission by virtue of being the departmental justice for the 25th. What we'd like to do, I think, is what you're expecting. We have 45 minutes set aside for this. If it goes short, it goes short. If it goes long, it goes long. But I would like to start this by giving you an opportunity just to introduce yourself to the commission, say, whatever you think qualifies you for the job, and then we'll open it up for questions and let the commission take it from there. Thanks.
Sure. Thank you very much, sir. Well, as you're all aware, my name is Richard Marquez. I also go by Rick. I've been practicing out here for, it seems like I'm approaching 30 years. Upon graduation from law school, I worked for State Farm Insurance initially. I hadn't taken the bar yet. My wife was pregnant, and I needed to make sure that I had a job that would not be contingent upon passing the bar, because there's always a chance you don't pass it. And so I had to make sure my family was taken care of first. It was actually a very good move in the long run. I kind of specialized when I was at State Farm. I handled larger bodily injury claims, plus I did arson and fraud investigations, which I really, really enjoyed. From there, I went to the JAG Corps, where I was a captain in the United States Army. JAG means Judge Advocate General. I was except for about a 6-month duty stint in legal assistance, I was principally in trial defense service, which meant that I was like the public defender on post. And I did extensively defense work and handled everything from failure to repair, which means you showed up late for work, all the way through murder and rape charges. So we kind of handled the gamut of things there. Trial experience was extensive in the JAG Corps. I think I did my first trial when I'd been on the job as a PDS officer for maybe a month tops. From there, I went to Wallace Saunders, where I was which is a defense firm. It's Wallace Saunders, Austin Brown, and Enix out of Overland Park. And I was basically a trial attorney there. We did insurance defense work, and I kind of gravitated back into my position of handling arson and fraud work. And then made the decision to move out here after about 2-3 years at Wallace Saunders, mainly because I thought it would be a great move for my kids. I'd grown up in Overland Park, and my grandmother on my dad's side had lived in Wichita. My cousins lived in Wichita, and we saw them maybe once a year. And we've got 5 million family members out here, it seems like. And so my kids grow up with their grandparents, cousins, aunts, uncles, very, very tight family relationships. So it was a great move. And out here, I've done just about everything there is. I've done extensive criminal defense work. I've done extensive civil litigation. I've done tons of family law. I've done just about everything that comes up in a general practice. Out here, we can't really specialize so much. You can, but you're kind of limited on what you do. And I wanted to do a wide gamut of things. I think those experiences are what qualify me to be considered for the position of the judge. I think that you want individuals in that position that, number one, have good people skills. And when I'm involved in whether it's a serious criminal case, a minor criminal case, a family law case, a big medical malpractice case, a products liability case, it doesn't matter. You've got to be able to work with co-counsel or opposing counsel in those cases. You've got to be able to get things done, and you've got to have at least somewhat of a semblance of a relationship in order to try and get the case resolved economically for your client, or to at least go into the trial and be thoroughly prepared and present as good a case as you can in front of the jury. And I think our experiences, or my experiences, are exactly what we need in our district at this point. I don't mean to be critical of any of the other candidates, but I've done it all. I haven't limited my practice to just a criminal practice. And I've done litigation. I've tried cases in the federal court. I've tried them in state court. I've tried them in throughout southwestern Kansas and in Missouri as a co-counsel in the federal court there. So I've kind of done it all, and I've got a wide range of experiences. I think I've tried to allude to that in my application. I've tried to include information concerning what I think are my biggest 5 cases that I've done, and why I gave those to you, so you could understand the breadth and complexity of the issues that I handled. And I think I can handle just about anything that's thrown at me. So that's me briefly.
All right, thank you. Let's open it up for questions from the commissioners.
Yes, sir.
Rick, I do, as you know, a lot of family law. And we know that there are factors that have to be considered in every custody case. We also know that there's so much discretion that can be used by the court that, judges do call upon personal experiences and other things in making those determinations. You and I also know that sometimes it's difficult if you can't, or if you don't know a judge's tendencies. It makes it more difficult to advise a client on the likelihood of some sort of a result, which in turn makes things kind of a free-for-all. Do you have any, as far as custody and visitation, we know that there are judges that really like, a 50-50 sort of a shared arrangement. There are judges that prefer, hey, let's just keep it every other weekend, every other holiday, what we call a standard claim. Do you have any thoughts or have you formed any opinions on what your likelihood would be to choose one custody arrangement, visitation arrangement over another?
Certainly I do. I'm getting huge feedback. Is there something going on? Can you hear me? Am I blowing you away?
You're good. You're fine.
Okay. Number one, if it's a father who, for example, wants to come in and have parenting time with his child, I absolutely believe that any non-custodial parent who doesn't necessarily want shared custody or full custody is absolutely entitled to at least the standard minimum. I mean, I'm a big proponent that fathers and or mothers have a right to parent their children. And Bill, you know as well as I do from our experiences, I don't really like it when somebody's messing with somebody else, and it's really more of a power play as opposed to really what's in the best interest of the kids. So I'm a big fan of parents who want to parent having the right to parent their children. I'm not sold on shared custody as a starting point. I think, at least in my experiences from having done it for so long, so many times it becomes a game over child support as opposed to exactly what is really in the best interest of the child. Would I rule out shared custody? Absolutely not. But I need to hear some reasons from somebody on why. And sometimes you don't have great reasons. Sometimes it's just, hey, I've always been there. Our relationship didn't work out. We're going to split the sheets. But gosh darn it, I've been a good dad or a good mom, and I want to have equal access to my kid, and we live in the same town. Sounds pretty compelling to me. So I would certainly consider those factors at that point. So did I answer your question, sir?
Yes, thank you.
Sure.
Rob, I think you're muted.
There, my phone keeps ringing, so I try and turn it off. Rick,
Yes,
in
sir.
the domestic area, which thankfully I don't tread very often, there's kind of movement in judges' philosophy as to folks starting in the same community, one of them needing to move, and they go back to court. And of course, the parent who is still there wants to prevent the move in effect by saying, I want the kid now. What mileage are you going to apply? How are you going to resolve that if you have two good folks who've been doing a good job and somebody just, the teacher changes a district or those sorts of things happen?
Well, the case law in that area kind of gives us some criteria to go by. And, obviously, if they've been raised, for example, in the Garden City community, and let's say the child is 12 years old, he's got all kinds of sports activities he's involved in, close associations with friends, etc., good relationships with teachers, is a really good student, etc. If I'm judging that thing, I'm going to look pretty hard at, let's say it's mom that wants to move away. I'm going to say, give me some substantial and compelling reasons on why this move is going to be in the best interest of the child. Because mom and dad can move and it's not so hard on them, but it's pretty devastating on a kid if he's not geared up for it and if he's going to have to abandon, friends, teammates, etc. I also recognize, having been in the military and where deployment, changing orders, etc., is pretty common, kids are pretty resilient and they have the ability to adapt to a ton of circumstances, particularly military kids. And a lot of them end up being very well adjusted individuals and leaders in our communities. So I'm going to look at the facts. I'm going to listen to what the parties have to say. But at the end of the day, maybe it's just a gut feeling where you kind of go, no, I'm really getting a feel for this is where the kid should be at this time. But I'm certainly going to consider everything. And I think that's the only appropriate way to do it. I guess, Rob, I don't think there's a bright line test for that per se. I guess that's what I'm saying.
Okay. Thanks.
Yes, sir.
Hey, Rick, what changes would you like to see in state's judicial system?
You mean at a criminal level, domestic level, how we handle dockets? What do you mean, sir?
Yes. Just as a general philosophical change for the judicial system in this state.
Well, number one, when we have individuals sitting in jail, we need to get them processed quickly. We need to get bond established for them. We need to get those folks moving so they're not just sitting there spinning their wheels. A lot of my experiences have been most of our folks who get into trouble, they're not bad people. They just make bad mistakes at a bad time, and they have jobs, they have kids. They have to keep supporting their kids, even if it's a criminal case, obviously at a lower level. And so therefore we need to make sure that we're getting a reasonable bond set for them. We're getting them processed and we're getting them back into the community and working towards resolution of the criminal case, whether it be through diversion, pretrial deal, or ultimately a trial. But I think it's important we do that. I think in the domestic arena, I'm a huge fan of mediation. I didn't used to be, because I thought, well, that's what we get paid for, is to try and work these custody situations out. But about over the last 8 to 9 years, I've really grown to appreciate that, look, in a domestic context, the litigants perceive us as confrontational, as adversarial. So the ability to work out some custody or parenting time arrangements is difficult just because of that tension, that dynamic that exists. And Mr. Heidman does mediation, Susan Richmeyer does mediation, and frankly, I've seen them pull off miracles where I thought there is no way they're going to get this case resolved. The advantage to that mediation is, obviously, it saves wear and tear on the parties, saves litigation fees, et cetera. And so where I'm going with this is, I'm not certain that the litigants appreciate why this is important. So many times they see it as, well, an order was signed and I guess I have to do it. So I've thought about this, and of course I would discuss it with the bar if I got the nod, having a short hearing where I would have the litigants in the courtroom and I would tell them, I'm going to order mediation in this particular case. And folks, let me tell you some reasons why. And I kind of have some factors that I discuss with my clients even now about why I think mediation is important for their case. And that way, maybe it's a little bit more, allows them to focus a little bit more in lieu of just our attorneys telling our clients, hey, yeah, we got to go to mediation. No, let's try and make it more meaningful and explain to them the reasons why. That doesn't mean that counsel don't do that job, but I've been doing this long enough to know you can sit there and talk to your client all day long and tell them the same darn thing that a mediator says, but it means more when a judge or a mediator says it to them because it's not their lawyer telling them. It's a quirk on the way our relationships work, but I've found that that's pretty effective, at least in some of the mediations I've been involved in accidents and things like that. Civilly, when we have a large civil case, I firmly believe that attorneys that are involved in, whether it's a med mal case, construction defect, breach of contract, whatever, if they're good lawyers, they fully understand what needs to be done on their case. And I probably would take a little bit of a hands-off approach as opposed to being a micromanager. I would probably set, if I hadn't heard from anybody, maybe 6-7 months into the case, probably get at least some thoughts on discovery, because we do need to get those cases moving forward. I would anticipate that counsel would contact me in advance of that, but that would kind of be my game plan, because if you're involved in a high dollar case, it takes a while to get stuff done. You got 4 or 5 sets of lawyers, you got experts scattered all over the country, you got to send out interrogatories, you got to do depositions, and they're just tough to get to a place where you need them to be. So I would try to be extremely flexible on those higher end cases, of course, recognizing what the issues and damages are up front. So that's kind of where I would be at on that. Does that answer your questions, Mark?
It does. And then just kind of as a follow-up, in business litigation matters, what would your policy be with regard to alternative dispute resolutions? Any particular forcing mediation? How would you handle that?
Well, I know at the federal level, it's pretty much mandatory, and we have found that to be, in the federal cases I've been involved in, incredibly effective for the parties. I was involved in, it wasn't a business litigation, but it involved elements of loss of income and things of that nature, a substantial case down in Seward County. And although mediation wasn't ordered initially, we engaged in pre-suit mediation. I had the plaintiff in that case, and there were 5 defendants, and we knew what our damages were that early. We were able to document everything, and we had, I think we produced over 2,000 pages of documents in that case. And we didn't get it resolved that day, but it kind of let the parties know where we were at, and we had to do some litigation. And then Judge Ambrosier came in and he ordered the parties into mediation. So I would be prone to, if not order it, highly recommend it, because the litigants, they don't understand how expensive this can be. And they don't understand the time commitment that it's going to take. And they don't understand that resolving the case amicably actually benefits them in the long run. I think insurance carriers understand that. I think big business do, but the average plaintiff doesn't necessarily do that. And boy, I tell you, we got some great mediators in this state, particularly if it's on a business case or on a civil context type case. And they know how to work things, and they know how to get parties to where they're looking at different options. So if I didn't order it, it'd pretty well be highly suggested.
What about a case, Rick, where one of the attorneys says, you know, we are not gonna settle this case? I mean, you can order me to mediation, but I can tell you that our risk committee, our owner, whatever, they're not gonna pay anything. What do you do with a case like that? Do you still make them go?
Well, I think the difficulty becomes at that point that if you have somebody who says, I have absolutely no authority, I will never have authority, then you're absolutely right. Mediation's a waste of time. So there has to be some unanimity of opinion that, yes, this is a case that we should at least consider settling. But if one of the parties saying, I will never have authority, and there's a certain lawyer at a Great Bend who told me that regularly, and we just didn't waste our time on mediation. Now, by the time we got to pretrial, all of a sudden we're talking a little bit more frequently about mediation, and then we would go to it and we would usually get it resolved. But if the initial feedback up front is, it's a waste of time, we're not going to do it, I don't think it's fair to the plaintiff. Because if it's the defense attorney that's saying, we are never going to have authority, our risk management committee has said this is not a case we should settle, then usually what do we do in a mediation? The parties are ordered to share it equally. Well, I can't penalize the defendant for telling me up front, we're not going to have authority and we're not going to appreciate your making us pay for this. So if that circumstance arose, I guess I'd tell them, well, I guess you better get your shoes on and get ready for court then. But the goal is hopefully the parties would at some point want to do that. Did that answer your question, Zach?
Yes. And
Okay.
Do you have any experience with mediation in criminal cases, and what's your thoughts on that?
You know, ironically, I do. It's been a long time. I can't remember if it was Thomas Richardson or Judge Frederick that mediated a couple of criminal cases I had. But the issues were so large in those cases, we really weren't able to get much done. I know I've heard that Judge Worst has started doing those, and I just don't know how successful they've been. I've been very fortunate that in recent memory, the higher end criminal cases I've handled, I've been able to get things worked out very satisfactorily for my clients. It's only through hard work that we are able to do that, but I was able to get those resolved in lieu of mediation. I will tell you that down in Judge Ambrosio's district, Linda Gilmore routinely mediates domestic cases for Judge Ambrosier, and ironically, we've had very good success with her doing that. So that's the best I can give you at this point. I haven't had it happen in recent memory. Let's put it that way. I'm sorry, I didn't answer your question. Do I think it would be beneficial? Absolutely. Sometimes the criminal defendant needs to hear, and sometimes the prosecutor needs to hear from a fairly neutral party. Here's the evidence the way I see it. This is where you're strong. This is where you're weak. Let's try and work towards something that you can live with. Because clearly the defendant's going to say, well, I don't want to go to jail. And clearly the prosecutor is going to say, well, we want you to go to jail. Well, again, I've been doing this long enough that unless it's a Jessica's Law case, there's always a possible way to get it worked out And I think a different set of eyes may be able to assist the parties. Just my thoughts on that.
Rick, I don't know how comfortable you are with Zoom world and all this. Obviously, the pandemic's taken us into stuff like today. I'm a firm believer, and I think science backs it up, or studies do, that nonverbal communication is actually more important than the other kind, verbal. The other problem I have is it used to be, and this is somewhat selfish, when a Wichita defense attorney took a drug case in Hamilton County, they were ready to plead by Pratt on their first appearance. And now we have to drag that clear to arraignment. I am worried about the Western Kansas bar and communities like Syracuse having one attorney, when Kansas City attorneys can practice in Syracuse by Zoom. As a judge, what will you do with that?
Well, if you're asking me, if let's assume it's a Wichita or Kansas City council, if it's a first appearance, I don't have a problem with that. I mean, it's unfair to the client to make them have their counsel drive all the way out on something like that. If it's a preliminary hearing, or if it's a suppression hearing, or a pretrial conference where we're going to be doing motions in limine, whatever, I'm not a big fan of Zoom. I like live bodies there. We've had some problems with Zoom at times. This COVID thing is completely different beast. I'm a big fan of practicing safely. I don't want anybody to get sick because of any actions I've got, but Rob, I agree with you. Sometimes you got to be able to eyeball that witness. You got to be able to read their body language when you're questioning them about things. And I'm not certain you can do that through Zoom. And so on something substantive, absolutely, I think the attorneys need to be present for that in some capacity. I mean, and I'm not a big fan of Zoom. If I can real quickly, I had an evidentiary hearing in Logan County about a year ago. And it was a fairly significant evidentiary hearing, and it was on a criminal case. And one of the witnesses had come down with COVID, and he wanted to appear by Zoom. And I think he was the sheriff or one of the deputies. I don't recall. The rest of us were in court, and it ended up that Judge Barron sustained my motion to dismiss. But we had huge problems even getting the sheriff to be able to connect. And I ended up not needing to call him because I got the relief I wanted. So I recognize the system's here for a reason, but I think it's different when we're dealing with evidentiary issues and we've got witnesses that are scattered about. So that's why I still prefer, I'm old school in that sense. I still prefer face-to-face conduct or confrontation. The last point I'll make is I attended a CLE by Zoom, ironically, in early June. And a very good plaintiff's lawyer was one of the speakers, and he was talking about Zoom, and he's probably 15, 20 years younger than me. And I think I'm pretty well technologically versed. But he was talking about how they do things by Zoom, and they've done depositions. And his opinion likewise was, yeah, Zoom's really good. Yeah, I can handle it really well, but I still like having a live body there because you get so much information through the deposition or trial process. So even the younger attorneys recognize Zoom has its place, but I don't think it's the ultimate solution. I really do like to have bodies there on substantive matters.
Along those same lines, Rick, what's your opinion on perhaps allowing an expert witness that's out of state to testify at trial by Zoom?
Well, we've allowed them to appear by videotape before. I remember I did a jury trial in Seward County, and my expert, it was cost prohibitive to bring him back. And so we videotaped his deposition and we played the videotape for the jury. So look, if it's a personal injury case and the injuries are significant, or if it's a construction defect case and you've got an engineer or an architect that's testifying, A, those people are incredibly busy. B, they are incredibly expensive, and you can wrap $25,000 up in just getting an expert to testify at deposition, then appearing for trial in Southwest Kansas, because it's hard to get here. And in those instances, I think I would allow that because it's cost effective for the litigants, and we're not making that expert take time off from his or her practice, whether it be as a physician or as an engineer, whatever the case may be. So in those instances, I'm okay. I would like to have the parties agree and stipulate on the record that this is an acceptable way of presenting this particular witness. So that's probably how I would handle that, Zach.
Rick, it seems to me like we've had some aspects of litigating under COVID that have been detrimental and difficult to adapt to, and some that haven't worked very well. But other things, for example, the ability to, or the willingness to use electronic formats in a more creative manner seem to have been beneficial. As a judge, do you have any sense of what things we've learned and gotten accustomed to during this era that you would find beneficial, and what things you think have been unnecessarily detrimental and should not be part of the legal community or litigation format?
Well, Lucy, I think that's a great question. And I think we're kind of learning on the fly what does and doesn't work. I do know, for example, that, I don't know, 6-7 months ago, I had to appear before Judge Wurst in the main courtroom. And it was almost comical, but it was really frustrating because Judge Wurst was up on the bench, and, you know, they've got plastic shields all over the courtroom. I had a mask on. People were sitting behind the shields, and I won't admit this to my wife, but I don't hear as well as I used to hear. And I couldn't understand Judge Wurst, and he was yelling and I was yelling. We were trying to understand each other. And eventually I just approached the bench. I kept my mask on and I kind of did this. So he pulled his mask to the side and told me what he'd been asking me. And I wasn't trying to be difficult, but that shows how frustrating even a simple hearing like that could be. So if it's a substantive matter or if it's a trial, I think we got to bite the bullet, and I think we got to figure out a way to get the litigants and the witnesses into court, and we've got to be able to present that in a format where the jurors can hear, and the judge can hear, and the lawyers can understand each other. And if it's an expert witness, for example, let's assume it's a shaken baby case, and you've got a neurologist or a pediatric neurologist as an expert. Obviously, much like I told Zach and or Mark, then yes, I think we can allow them to appear should either party decide or they both agree that they appear by Zoom. But I still go back to, I'm old school, and I just know the difficulties I've had in some of my own evidentiary hearings with trying to appear through Zoom. It sometimes it works, sometimes it doesn't. And again, if it's substantive, we're trying to protect the record for everyone. I think we're on the side of caution. We try to get folks there. Now, with that being said, I did have an opportunity to talk to Merlin Wheeler out of Emporia, because Judge Frederick asked me to, a year and a half ago, assist the court on what they're doing in other counties for this Zoom platform. Because some people were using Blue Jeans, some districts were using Microsoft Teams, et cetera. And so I called Judge Wheeler because he was kind of at the forefront of that. And he told me that they were taking arraignments by Zoom and they were working out fine. Some prelims were working out okay. And then they were doing lots of appearances, but he had not tried a case to a jury as of that time. So I think the verdict's still out on that. It's just my experiences have been a little frustrating with it just because you can't hear folks.
So I did a hearing in the main courtroom where we had an expert appearing, or not an expert, but one of our main witness or witness as to rehabilitative opportunities appeared via Zoom, and it actually went fairly seamless. One of the concerns that came to mind as I was listening to you talk about using Zoom for experts was the consent of both parties to that format. It seems to me that the right or the ability to confront and cross-examine is protected in the Zoom format. Do you think it's appropriate, if we're advancing to that level of technology, to maybe I can find a tremendous expert that my client can afford, as long as that expert can appear via electronic formats, but it becomes cost prohibitive if we have to fly them here and put them up. And so why should the state get to say, I'm going to prevent your ability to put on or to present this testimony because I'm going to make it cost prohibitive, even though your ability to confront and cross-examine is protected because of the format?
Lucy, that's a good question. And I don't think that when I was talking about trying to get the consent of both parties, I think that just makes things cleaner. I recognize that there are those instances, particularly in a criminal context, where it's a discretionary decision by the judge. And you're absolutely right. I mean, I've been doing defense work forever. And I want each defendant to have their day in court. I want them to be treated fairly. And you're absolutely right. When you're a criminal defendant, in 99.999% of the cases, as a defendant, if you can afford an expert or if you can get an expert appointed through bids, they're usually subject to some pretty strict financial guidelines. In other words, not too many people can afford to fly a pediatric neurologist in from California. So in that instance, I certainly want to listen to what the parties have to say. And I can tell you, I'm going to make sure that defendant gets a fair trial. And if I have to step on somebody's toes and say, look, I find it's in the best interest of everyone, it's fair, and it's a portion of due process for this expert to appear by video conference, that's the way it's going to be.
Rick, most of your experiences in the criminal side has been on the defense side. How do you go about setting a bond, and how do you balance your experience of, I'm representing people, they need to get out, they need to get back to work, they need to not lose their job, versus now I got a judge hat on and my duties are different. So can you explain how you balance that experience and possible bias of getting people out and back to work versus the county attorney and the people she's hired that we've elected to maintain order and safety in our community?
Yeah. I think I don't care whether I'm acting as a defense lawyer or whether I'm acting as a judge. And I can't comment on the prosecutorial side because I haven't been a prosecutor, but I know what the statutory criteria are for setting a bond. I think the analysis remains the same. I think you look at the severity of the charges, you look at the individual's prior criminal history, you look at their employment history, you look at their connections to the community, whether they're a flight risk or not, and you assess all of those factors, and then you establish a bond that you think is fair and appropriate. And if it's a first time domestic battery, not minimizing the impact of those, but they've been married for 27 years. This has never really come up before. He's been employed at Tyson for 30 years. All of his kids live here. He's got a good paying job. Maybe he's a supervisor out there, but they still scrape by on their budget. What do I gain or what does the defendant gain by establishing a bond of $50,000 cash or corporate surety, and he doesn't have $5,000 to come up with? So we kind of have to do that balancing act. Now, if it's a rape case, guy's got a prior history of being sexually violent predator, and this isn't his first rodeo, and he's not employed, he's kind of a drifter, etc. Completely different analysis. And the bond's going to be set based upon the severity of the crime and what his history is, and those other attendant factors that I identified. So I'm not trying to be evasive, but it's hard to give you just a blanket answer, because our job is to look at all the factors, listen to what everybody says, and then try to come up with something that's not only fair to the defendant, but also fair to the state and assures the safety of the community as well.
Any other questions? Anything? Well, if there's nothing else, Rick, why don't you just wrap this up by giving a couple minutes summary of what you want to say, and then when you're done, we'll take a break.
Yes, sir. Yes, sir. Well, first and foremost, I've served on a similar committee, and I know what a time commitment it is, and I know the amount of work that goes into it, and I know we're all busy, and I truly mean this. I truly appreciate your taking the time to serve on this committee and to listen to me talk about myself. I don't necessarily like to do that, but I have to do that today. But I truly do appreciate it. I think what you want in a district judge is you want somebody with a broad range of experiences, and I think I have those things. I think you want somebody with good people skills, and I think any of the lawyers on this commission or from this community or from wherever you want to call will indicate that I'm extremely easy to work with. I'm extremely tenacious, but at the same time, we're able to get things done. And I'm extremely flexible with other parties when they need continuances or we need to move things, et cetera, because that's how life is. Things happen and we're all busy. I've always been a quarterback, meaning when I represent clients, of course we consult with the client. Of course we talk about what's going to go on, but sometimes I have to make those tough decisions on, well, we're going to call this witness, or we're not going to do this, or I recommend you don't testify in this case, et cetera. And although I would be somewhat abandoning that role in lieu of becoming a district judge, I think that I'm still going to be a quarterback in some sense, because I got to keep the parties moving, got to try and address issues as they come up. And ultimately, I have to make unpopular decisions to at least one of the parties, if not both at times. And I think I'm prepared to do that. I understand the law. I'm a student of the law. I constantly go back and review information that I thought, no, I got this down pat, and I go back and double check my research just to make sure that I'm correct before I file a pleading. I spend a great amount of time writing briefs when I need to do those, and I do those frequently. I've involved myself in leadership positions in the community. I was an officer in the Army. I mean, so I know how to make those tough calls. I know how to make recommendations. I know how to work with people, for example, on boards that I've been involved in, et cetera. And I think those all translate to what you're looking for in a district judge. The final thing that I would like to throw out there, it's physically impossible for an attorney to handle every type of situation that would ever come up. So for example, if somebody were to say, Rick, what do you know about utility rates? Not much. But the thing that I've learned through my practice, because I haven't pigeonholed myself, and I don't mean that insultingly to anyone else, I know how to find out the answers to stuff. I did a med-mal case involving a ruptured uterus. I knew nothing about fetal heart rate strips. I knew nothing about hypoxia. I knew nothing about the long-term effects of cerebral palsy. And I had to learn all that stuff in a hurry. And we had to be able to effectively cross-examine nurses and physicians and those types of things. Now, if that sounds distasteful, I had a severely injured child and somebody had to protect that child. And that's what I did. And so the point I'm making is not to pat myself on the back, but to let you know, if you choose me and if the governor chooses me, I'm not going to slack off. I'm a hard charger. I work hard. I take my commitments very, very seriously. I think any lawyer will tell you that I do that. And you can trust me to continue working hard and to continue to treat the litigants and the attorneys with the respect and dignity that they deserve, quite candidly. Nobody wants to be in a litigation context, and I recognize that. A defendant doesn't want to be facing criminal charges. A plaintiff doesn't want to be an injured party. And a defendant in a company, they don't want to be sued. But you know what? They're entitled to some dignity and respect, and I'm going to give them their fair day in trial if that's what they want. And I'll do everything I can to assist the attorneys as much as possible as well. So again, thanks so much for taking the time and letting me answer your questions.
Well, thank you. We are scheduled for a break at this point. We're a little late to get to it, but I'll leave it up to the commission. We can either do a short 8-minute break, or we can take a 10-minute or take the full 15 and come back. I just need to make the announcement on that. Rob, I saw you were thinking 10. Is that okay with everybody? Well, then why don't we come back just a few minutes after 11? For purposes of the Zoom, you can just mute your mic and your video, but leave everything else running and go from there. Any questions? Thanks.
Thank you. Am I free to leave, sir?
You bet.
All right. Thank you, sir.
No, you're in
Thanks,
contempt.
See ya.
I should have told John that that 10 minutes was going to be on real time and not his.
Wait till I get off this.
I'll give John till 11:05 on my clock, and then we'll proceed. There we go. All right, Shelby, why don't you, as Magistrate Woods in the waiting room?
He is.
Okay, great. Why don't you
I'll
go
go
ahead?
ahead and
Yeah, go
bring
ahead.
him in.
Yeah. Judge Woods, can you hear us okay? Hear me okay?
Yes, I can hear you fine. Thank you.
And I can hear you. So we're coming back off of a break. We went a little long in the first half of the morning, and John Linder will be joining us, but there he is. You know, John, we're not Linder minutes are kind of like dog years. You know,
I was on a conference call concerning how to handle the Taliban. So, you know, it was fairly important. So
well, there you go.
I am sorry that I went a little long on that.
It's good to keep up with expectations, though. So I think that's fine. Judge Woods, we're now all convened. We have one member of the commission who is not going to be present today, but everybody else is here over Zoom. I'd like to have this session begin, you know, I think you expect this, to do a little introduction of yourself first, explain to us why you think you're qualified to do the job, and then we'll open it up for questions. And we've allowed for 45 minutes. We'll take the full 45 if we need it. We'll go longer if we need to. We'll go shorter if that's all there is. So why don't you start us off by giving us an introduction?
Okay, thank you. Morning, the Honorable Justice Biles, Mr. Secretary, and members of the Nominating Commission. I'm honored to return before you today as a nominee for District Judge. I would first like to take this opportunity to thank the countless family members, friends, mentors, and colleagues who have done so much over the years to make this day possible. I'm extremely grateful for their love and support. I would like to make a special note of thanks to my wife, Michelle, our daughter, Nova, and our two foster kids, Brianna and Bernadine. They have done so much to support my legal career, and for that, I'm eternally grateful. This commission nominates a district judge to serve all the citizens and residents of the 25th Judicial District. from Garden City to Tribune and Scott City to Syracuse. Counties that I have all had the opportunity to practice in during my career as a lawyer for child support and with Kansas Legal Services. The judge you guys will select will take an oath to support the constitutions of the United States and the state of Kansas to faithfully discharge the duties of their office. Since becoming the Finney County District Magistrate Judge last year, I took it upon myself to better serve the citizens of Finney County, expanding the previous magistrate caseload by taking on half the child in need of care cases, all the misdemeanor criminal and traffic cases, all the protection order cases, and all the extradition cases, as well as any pro se divorces that are filed here in Finney County. Despite the significant increase in caseload, I'm always prepared, always ready to treat everyone in front of me as a valued individual, and always strive to make sure that everyone leaving my court feels listened to and respected. My time on the bench could not have happened, though, without the amazing opportunities given to me during my time as an attorney, first with Kansas Legal Services and later Young Williams Child Support Services. I learned a great deal from my supervisors, Marilyn Harp and Brandy Ridgway, and most of those lessons on how to treat people in the courtroom that I learned from them have become the foundation for how I run my courtroom, where I am dedicated to following the law with commitment to fairness and making sure that the parties and attorneys before me are treated with respect. Yet, despite all the experience and knowledge previously gained, both in my time as an attorney and as a magistrate, I refuse to be complacent and satisfied with only what I already know. I attend as many judicial trainings as my schedule allows, learning whatever I can to become a better judge and fill in the gaps of what I don't know, or to improve certain practices that I already do. I have worked to build good working relationships with the people I work with on a daily basis, the courthouse staff, court services, the attorneys who practice before me, and the various agencies who provide services to members of the community who come before me in the courtroom. I'm confident in my ability to handle all the cases that may come before me, whether they be criminal, domestic, civil, probate, or administrative. Beyond learning to be a better judge, I'm also working to be a better leader and manager. I believe this is especially important for this district, as we are replacing one judge of great knowledge and experience, and will replace another long-serving judge early next year. So when that happens, I want to be in a position to do whatever needs to be done to improve whatever needs to be improved, and change whatever needs to be changed. I'm ready and willing for that, whatever role I can fill, whether it's to serve as chief judge, working with the court administrator, or to assist the chief judge with the administration of the district. If I am nominated and then appointed by Governor Kelly, it will be another step in a career dedicated to serving the public and ensuring that everyone receives an equal opportunity to have their disputes settled before the law in a fair and just manner. I promise that if I am selected, I will live up to the oath of my office and serve the citizens and residents of the 25th Judicial District to the absolute best of my ability. Thank you.
Thanks for that. Let's open it up for questions.
Judge Woods, in your application, you indicate that you wrote the top paper in constitutional law. Is that correct?
That's correct.
Yeah. What was the specific topic of that paper?
Honestly, don't remember. It was so long ago. I remember it was I believe it had to do with the 14th Amendment and the basically it had to do with the 14th Amendment and substantive due process. So people's fundamental rights.
Sorry, I was going back in time. I just noticed that. Thank you.
Tim, I'd like to commend you on what you've done so far as a judge. I think you've been extremely helpful to litigants. Congratulations. One of the things I'm curious about, and you in your position, you know it well, is we sort of have an evolution going on in bond philosophy. And, you know, we have essentially kind of both extremes in our magistrate philosophies. Where do you come down, and what are your thoughts on what the proper role of bond is? And I realize there's a statute and all that. I want something beyond just there's a statute and I'll follow it.
And there's also an amendment to the Kansas Bill of Rights that addresses that fact as well, basically saying that everyone is entitled to a bond unless it's a capital offense. My philosophy is that people should be given the opportunity to remain in the community if it's possible. I mean, I know we need to balance concerns about past instances of failure to appear. You know, we need to make sure they do attend court and to get their cases resolved in a timely manner. And there are also the concerns about safety of the public, but I think there needs to be find a way to make sure that an OR bond is the preferred method rather than locking someone up. You know, as a sink judge, I see, you know, parents get locked up and then everything falls apart. Like they lose their jobs, they lose their house, they lose their kids, and everyone, their employers, their landlords, the kids get hurt in this instance. And I just think that it's better for everyone if you can find a way for people to remain in the community. I've been talking with the folks at Court Services, and I think they recently hired a couple more people, and there may be the possibility that they can have a pretrial supervision officer, you know, to remind people to go to court and to keep them on the straight and narrow while they're waiting for their day in court.
Where do you draw the line on OR bonds?
I know it's kind of a hard question to answer. It's kind of I'll know it when I see it. The things that would cause me to be hesitant to maybe an issue an OR bond would be, you know, like the severity of the crime, the risk of flight, danger to the community, past history of not appearing. But I think at the same time, you do need to take into consideration that some people have more money than others, obviously. So a bond amount should be set as what is appropriate. Or I guess what I'm trying to say is that if a bond amount is set, it should be set at an amount that fits the person's particular financial situation.
I mean, if you've got a person felony or a Jessica's Law case or something like that, does their financial situation really matter then?
I think as the Kansas Bill of Rights stands, those aren't capital offenses, so I mean, I think I understand where you're coming from. Like sometimes you would set a bond higher depending on the particular case, and it just may be out of the reach of certain people. But if the risk to the community is great enough, that might justify setting the bond that high.
Have you had a chance to set bonds in your work as a magistrate, and how do you juggle wanting people to be back in the community, be working those things with, you know, a county attorney or assistant county attorney standing in front of you saying, this guy's a danger to the community, he needs to have a high bond? Have you had a chance to do that?
I have, I used to regularly handle the morning 8:30 first appearance dockets. And I would do arrest reviews. I still do occasionally when I'm needed. I don't mean to disparage the folks at the county attorney's office, but they seem to have a very formulaic response. Like they seem like they want to lock everyone up. And I've seen a few cases where you just look at the person and look at the situation and they're just not a danger to the community, but they still want a high bond. And at that point, I just draw the line and say, well, try them out on an OR bond and see what happens. But there are certain cases, I guess, like you mentioned, Jessica law cases, major person felonies involving great bodily injury. In those cases, I have set bonds a little bit higher. And I know after my last meeting, I got kind of raked over the coals by Mr. Lindner over what I did to his client. And it kind of caused me to rethink my bond philosophy. And that bond really needs to fit the crime if an OR is not possible.
Would you agree there are some person felonies with great injury and some serious offenses like Jessica's law offenses where the circumstances are such, like we've had Jessica's law cases where the individual doesn't get charged for 5 or 6 years and there's no current contact with the alleged victim, or it's very evident that the personal injury was grievous harm was a fairly episodic thing, unlikely to be repeated. How formulaic do you see yourself being in those cases, or do you think those are considerations that justify a lower bond even though the seriousness of the offense may be higher?
I think that is definitely something to consider. With the passage of time, if there's been minimal contact with law enforcement since the incident, and very few instances of violence, that should definitely be something to consider in terms of lowering the bond.
One of the things we seem to run into so often is the argument that this is a presumptive prison offense and therefore the defendant poses a higher flight risk. How do you feel about that argument?
Again, not to disparage our friends at the county attorney's office, but a lot of times I kind of feel those are very canned answers. And while that could be something to consider, you consider everything. And I guess going back to your situation, if the person's been in the community for several years before they get around to charging the person, they've had plenty of time to flee, and yet they haven't. And they might even have ties in the community that would definitely lean towards keeping them in the community.
Kim, if you become our district judge, and you come to Hamilton County, will you remember that the prosecutor is different than the ones you deal with in Finney County? And that I am always reasonable?
Yes, in fact, if I am appointed to be the judge and I will say that if I become the chief judge, I promise to visit your county at least once a month.
Good.
I had the pleasure of practicing in front of Judge Hood, and he always told me that it was important for a chief judge to always ride the circuit because it's important to have personal connection with the people you serve and to get a chance to see how the court is operating and see what kind of help they might need and not forget about them.
Speaking of personal contact, how do you feel and where are you going to come down as far as the live court work with real people, real witnesses there, as opposed to all the Zoom and all the little mini TV shows going on? Poorly produced normally.
I would definitely prefer in-person court, but I also see the benefits of Zoom, allowing Zoom witnesses if parties can agree to it. I'm a big believer in improving access to justice, and sometimes having witnesses or parties who don't live in the area be able to appear by Zoom would definitely cut down on the cost of litigation. And I'm speaking as someone who used to have to go to Elkhart occasionally, and only to have nobody show up for my hearings. So I guess I'm just saying that while I would prefer in person in the courtroom so I can get a feel for how the witness is testifying and assess their credibility, I think Zoom is a good thing, and I like to use it wherever possible, as long as everyone's on board with it.
What do you do in an instance where one party wants to have an expert who's probably out of county, out of state, testify by Zoom, and the other party objects?
I believe that would be a question of weighing the needs of having the witness in the courtroom versus the cost and burden to the party to get that witness to the courthouse. And I just think that that's what we need to be considered. I can say that speaking from personal experience, I guess going back to the Zoom question, I don't feel I've had problems assessing someone's credibility by Zoom, but I know that some attorneys like to play to the courtroom, and I can see why they might have a problem with it. But again, in answer to your question, I just think it would be a balancing act between the benefit to be gained by having the person in the courtroom versus the nature of the burden and the cost to get that expert to the courthouse.
What do you mean by the lawyer playing to the courtroom?
I've had a PFA hearing where a attorney would like roam the courtroom and kind of stalk around the witness, almost like he was a tiger about to pounce. And I will say that a few times in that hearing, I kind of had to warn the attorney to back off and, mind going off sides, I guess, to use a sports analogy. But there are some attorneys who like to do that, and I don't fault them for it. It's just the way they practice, but that's certainly something to consider.
And I want to go back to your comment about chief judge. You had indicated that something that you would do if you were chief judge is ride the circuit on a monthly basis. Are there other things that you would do? I mean, obviously you've observed chief judges in our district. Are there other things that you have thought of and that you would change or do differently that you feel like would be beneficial to the bench and bar as a whole as a chief judge?
I actually have a big list of paper right here, but I think I'll touch on a few of the points that I believe in. I think one thing a chief judge should do is listen. I mean, invite the local bar and the public and give them an opportunity to speak to the chief judge and talk about ways to improve things. It doesn't necessarily mean I would do it, but they should have the opportunity to say something, because what they could say might be a benefit to the administration of justice as a whole, and improve our practices to better protect people's rights and better serve the public. Sorry, I'm just looking at my notes right now. And I think probably work with all the judges together to come up with like a set schedule for things. So that way attorneys don't feel like they're running all over the place between 4 different courtrooms on the same day, when you might have like this judge is handling criminal stuff on this day, this judge is handling criminal stuff on this day, the public defenders get this block of time on this day. So that way they can stop having the runaround time and have more time to be able to get the work done. That's something that I've worked with the attorneys that people refer to as the Super Six, the misdemeanor and child in need of care appointment attorneys for here in Finney County. And I think we've got a system worked out, and recently we made some more changes to make it even more efficient than the original plan back when I started.
Thank you.
Judge, the elderly gentleman from Hamilton County was talking a moment ago about how reasonable a prosecutor he is. And then Lucy before that brought up presumptive prison offenses on bonding. That begs the question, what are your feelings about the sentencing grids and the use of the sentencing grids? I understand that there are certain statutory requirements, yet if departure criteria are met, then your hands are freed somewhat as a sentencing judge. So what is your general philosophy about the sentencing grids?
I grew up in California, and until recently, I would say that their sentencing standards were pretty harsh and very discretionary. And learning all that I know since I've become a judge in my practice in law school about the Kansas sentencing grids, I actually find them to be very fair. In the interest of weighing a person's criminal history score, the nature of the crime they're doing, the aggravating and mitigating factors. And I mean, personally, I have a philosophy of corrections, I guess you could say, from what I've learned about corrections in previous classes I've taken, that we need to find the least restrictive method to manage people who are on corrections or probation. So I generally favor probation if it's possible and if it's warranted based upon the situation.
If the attorneys present to you a plea agreement that includes departure, are you going to require a dog and pony show to make sure that everybody gets through all the right hoops, or is the agreement generally going to be sufficient for you to follow the recommendations?
I would definitely take a look at it on a case-by-case basis. But I believe that, the county attorneys and the prosecutors, that they're there to represent the interests of their community. The defense attorney is there to represent the interests of their clients and to get, the best possible deal and get what their client wants. So generally won't put everyone through a dog and pony show. If depending on what I read in the sentencing report, I might have a few questions, but I'm not going to I guess what I'm looking to say is that, like, I would never be one to look for ways to overturn somebody's plea deal and sentence them to something other than what was agreed to. Because, I would definitely give deference to what the prosecutor and the defense attorney has come up with before me.
Have you found, while you've been on the bench, that you tend to give more deference to the positions of state agencies and their contractors than other parties to a particular proceeding? Is that something you've run into and had to weigh?
In the child in need of care field, I often see positions of the state, whether it's through Ms. Schartz or whether it's through the agencies. And while I listen to what they say, I guess it's a situation where while I will listen to what they say, I don't give them the right to decide what my ruling is going to be. My ruling is going to be my ruling. Without going too far into details, I did have a case where a child was away in a group home, and the parents had a plan on what to do when they got home. The child had significant issues, but while the state and the agency wanted that child to remain in the group home, I just saw that it wasn't a situation that was best for the child based on what I heard and the information presented to me. And so I sent the kid home. So I don't rubber stamp any decisions, I guess is what I'm trying to say here.
I have listened with interest to what you have said so far, and with particular interest to your references to perhaps being the chief judge. I find it interesting that in this position, in applying for the district judge, position, and if you were chosen as a nominee, then you would go to the governor, and then you would have to be chosen by the governor, come back, and so on. You'd have to be in office as a district judge, and perhaps at some point appointed as district judge by the chief judge or chief justice of the Supreme Court. I find it interesting that your mind is working at this point, and you're talking about being the chief judge. Can you give me some insight on that, why that is?
I believe that, with everything going on in society, the COVID, the pushes for judicial reform, I think now is the time to try to bring our district along with a lot of those improvements. And I just feel that, like, for one thing, Judge Wurst has threatened that if Justice Luckert makes him chief judge, he's going to retire the next day. And I just feel that from my previous experience with management with Kansas Legal Services, my ability to work with members of the community, I believe I'm in a position to be able to take what we have now and find a way to improve it to the best possible solution for everyone. You know,
So you-
not just the judges and the prosecutors, but the defense attorneys, the public as a whole, and the agencies who come before us to help us out.
So you envision yourself at this point in time, you envision yourself in the role of chief judge of the district, and you believe that you would be able to make improvements. Is that a fair statement?
Yes, I believe I would. I've already made improvements to my little fiefdom, I guess you would call it, as magistrate. And I think that those improvements can be brought around to the whole district.
Your writing sample was a brief about the doctrine of necessaries in a medical bill collection case against a spouse. The doctrine of necessaries, where a spouse is responsible for a spouse's medical bills, whether they've agreed to be or not. What's your feeling about that doctrine? Do you think that that is something that should be the law of this state or should not be, particularly in this day and age of fewer and fewer couples actually getting married, which is the nail that causes the doctrine of necessaries to exist. I'm sorry that got so long, and I can start over if you need me to.
I think I understand what you were saying. I believe as it was decided in my case, which was decided in my client's favor, there are situations where medical treatment would be provided only upon a spouse's credit. And I think in those situations where, you know, a spouse is either guaranteed or services are only provided because of that previous promise from the spouse, I think in that situation, the doctrine of necessary stands. But I think, sorry, I'm just trying to think my way through this one. I guess what I'm trying to say is I don't think it's a doctrine that should necessarily go away now, but I definitely understand what you're saying, and then it's probably on its way out with less and less people getting married nowadays. You almost create a situation where it'd be unfair to married couples to be on the hook for their spouses' medical bills when they are in the minority.
You mentioned earlier in an answer about obtaining community input. How would you go about doing that?
I think that would just probably being a little more media savvy and, you know, reaching out to the public, whether it might be through social media, even though I don't use it, or maybe through various community agencies, or working to build ties with leaders in the community to get the word out, to seek community input regarding ways to improve the administration of justice in this district.
What changes would you make in the Kansas judicial system if you were given complete authority to do that? Just philosophically.
That's kind of it's kind of a big question. Just give me a moment to think about it. I I mean, I'll say, I just want to say that compared to California, I've found Kansas's legal system to be reasonably fair. I mean, reasonably more fair than certainly than California's. Just the big one I can think of is that I think we need a change to the Bill of Rights in addressing bond to come up with a better way of thinking how to do it. And I guess maybe ultimately what I'm saying is that just in my experience as a magistrate judge, I haven't seen a whole lot that I want to change. But I think that things can be done a lot more efficiently and done in a way that's a lot more fair to the people who come before us, to get their cases resolved in a more timely manner. It's something I've studied is, how different courts handle the resolution of the cases before them. And I just think that we need to figure out a way to get people before court sooner, get their cases resolved sooner, and kind of, send them on their way, whether it's on probation, whether they're divorced, whether their civil matter is dealt with. Just things need to be done faster and in a more fair way.
How do you balance that against the right of the parties to conduct discovery? Many civil cases, it's not uncommon to have 9 to 12 months or more of a discovery period. So how do you balance that desire with the rights of the parties to fully avail themselves of the discovery process?
Well, again, I think it's a process where me as a judge, I definitely listen to the parties. And in civil matters, I think parties should be given great leeway to determine how quickly they get their cases resolved. I think discovery is important because it can lead to settlement, and it can definitely help with trial strategy to figure out whether or not a claim is good or not. So I think in the civil arena, discovery can be a benefit, and they should be given a fair amount of time. But I think like in criminal cases, especially like in low-level felony drug possession cases, those cases need to be sped along because it's simply a matter of, did the person have the drugs? Yes or no? So what are we dealing with here? What's your defense? Not to make light of those cases, but in the criminal arena, there have been some cases that have dragged out for a while. I've seen them and I've worked to get them resolved, but I guess what I'm trying to say is that while I agree that the court system should be sped up and be as efficient as possible, in cases like the ones you suggest, sometimes slowing down would be best. But you just got to take it on a case for case basis.
And then how do you feel about mediation or alternative dispute resolution, whether it's in a criminal case, a civil case, a domestic case? What was kind of your philosophy on ordering mediation or using that process?
In my law practice, I've come across mediation in two ways. First, it was the domestic mediation, and I wholeheartedly support domestic mediation as it relates to, parenting plans, because there's no way that some upper middle class white guy is going to get all the evidence needed to know everything about your child to make a full decision on what's best for the child. And in that case, you should definitely try to have the parties come together and figure out what they know about the children and come to an arrangement on what's best for them. In the civil arena, I see mediation as a definite benefit to try to get the parties to an agreement, but if not, maybe closer to settlement if that's possible, or to figure out what the issues are. I've had some experience in this. When I was with Kansas Legal Services, I trained to be an attorney for the Kansas Agricultural Mediation Service through the Kansas State, and it was a good service because it allowed farmers who may have been facing foreclosure on their property to sit down with an attorney and with their creditor and with a mediator to try to come up with a plan or find a program that would allow them to keep their farmland while also satisfying the creditor's needs to get paid back on their debt. In the criminal arena, I think mediation can be a good service. It can get the parties to sit down and maybe consider, having a neutral third party determine what might be the strengths and weaknesses of their cases and come up and figure out what people want out of the case and hopefully come together to reach a solution that benefits the defendant and the community as a whole in terms of settling a particular criminal case.
Did you successfully mediate some cases with distressed lenders?
I was never given the opportunity to. Not a whole lot of people applied for the service, but I trained for the program. I know how it works, and I've met with a few clients to prepare them for mediation, but they ultimately decided to go another route, I guess you could say.
Okay.
Any other questions? Well, Magistrate Woods, if you want to take just a couple of minutes to wrap up, we'll conclude your session here.
Okay. Want to thank you all for the time and opportunity to speak before the nominating commission. I know that no matter the outcome, I will continue to serve the citizens of the district in the way I can, whether it is as a district judge or whether I continue on as my role as a magistrate judge. Believe that I'm prepared to move on. I believe I have the mindset to work with people on a higher level as a district judge. And I believe that the relationships I've built would serve me well to be a judge of the 25th Judicial District. Thank you.
Thank you very much. Well, that will drop you out, and if everybody's okay, we'll just go ahead and transition to our final interview for the morning session, and that'll be Magistrate Christopher Velez. Magistrate Velez, can you hear me?
I can. Can everybody hear me?
Yeah, you're kind of set up like a disc jockey. That's good sound.
Well, I do have a little podcasting / recording area in my apartment, so I figured why not make use of it?
Well,
I think I get the over the years microphone, the over the years headphone award this morning because I think of everyone who's participated, I'm the only one who's rocking like this.
well, you're familiar with our process here. You know, I'm Dan Biles. I'm a non-voting member of the commission and I facilitate things. We've got 45 minutes reserved for your interview. We'll take more or less depending upon how the questioning goes. But it'd be good if we could start out with you explaining as an introductory matter just why you think you're qualified for the job and, you know, what you have to say.
Absolutely. And I will try to keep it quick because I know I'm infringing onto everyone's lunch hour because you guys are on Central Time while I get the privilege of being on Mountain Time. I'm Christopher Velez. Most of you, at least the attorney members, know me as CJ, and everyone else probably knows me as CJ too from the number of times I've been in front of you all in the last 5 years. I've been around the law since 1999 when I was a tender age of 14, at which point I started working in a law firm's basement. It was a PI firm in Delaware of about 20 attorneys and a total of 100 employees between the staff and the attorneys. I started when they did a new network install. I started working IT for them, and I did that part-time through high school and undergrad. And then when I went to law school, I clerked with them. I got out of law school in 2010. I hung around Delaware, kicking around doing things for about 2 years. And then I came out here in 2019, got my license, came out to Garden doing child support enforcement for Young Williams for 6 to 7 months in the 25th and 26th judicial districts. And then I went and hung my shingle I was a sole practitioner for 6.5 years. I did a little bit of everything. When I first came to Garden, I would tell people back east that Garden City had one of everything. That was how my practice felt because I did a little bit of everything. I did some criminal appointed work, did a lot of domestic, a lot of evictions, a lot of probate, a little bit of limited civil litigation, a little bit of Chapter 60 civil, some adoptions, just a little bit of everything. I did that for 6.5 years, in which I was the only person in the office for probably 3 of those 6.5 years. And then I had one staffer who was helping me for the rest of the time. And then in May 2019, I became the magistrate in Syracuse, where I have been doing primarily criminal and traffic stuff in Hamilton County with a smattering of limited filings, the odd adoption, the odd probates, just the normal small county stuff. For the first probably 9 months that I was on the bench, I was under the old pre-COVID system in which the magistrates came into Finney County to do work. I came every Wednesday. I had the traffic docket for Finney County that subsequently was transferred when Judge Woods came in and took over not all of, but the majority of the Finney County magistrate duties. I then just kept doing my Hamilton County stuff. But with the time that was freed up between COVID and not having to do traffic, I have set about modernizing my courtroom and my practices. I would have said we had not changed practices in Hamilton County in 20 years when I started. We probably covered 15 of the 20 years that needed covering in the intervening 18 months. And as Rob is smiling, he could attest to that, to how far we've come. I would say I've worked on both physical infrastructure solutions and, more importantly, process design, trying to get actual workflows and just the handling of the court's activities working better, both for me, for the clerks, for counsel, and for everyone in this world in which we live that has been created by COVID. And that is more or less my pitch. I believe at least my history, my pitch is I believe I've done well as a magistrate. I've done good work. I believe that being a district judge is essentially a magistrate, but there's more responsibilities, but the work routine is basically the same. The constituents change. I do a little experience with a little bit of everything. I've been exposed to everything from PI to oil and gas to adoption to 2 months ago. I did a action, started as a small claims replevant action that basically turned into a divorce property trial between two pro se individuals on my small claims and limited dockets. And I believe I throw myself at these things because with the time I'm afforded, and that this is a calling more than a job. You do have to make sacrifices with this, and there are expectations that you will be available when needed. And I try to live that. So I will yield the floor to questions, thoughts, commentary, anything and everything anyone might have for me this morning.
Any questions?
You're muted, Rob.
Yep, sorry. CJ, one thing we've been asking all of the folks is about bond philosophy. And I would say that is something you do feel strongly and have a pretty developed philosophy. Could you share that with us?
That is absolutely something I have a fairly strong take on. In this district, we kind of have a bell curve of bonds. I anchor one end, and Judge Frock probably can be said to anchor the other. My outlook on bonds was really transformed by the work I helped Judge Wurst do on the pretrial justice task force. There is a constitutional presumption of freedom for individuals. It's why we have a requirement that there be a bond issued except for a very small class of cases. And I've always taken that to mean not only are they entitled to bond except in those narrow class of cases, it must be the least restrictive bond necessary to accomplish the goals set forth in the statute of protecting community safety and guaranteeing arrival at court. What this has evolved into is, for misdemeanors, my operating assumption on a misdemeanor is that someone is going to get an OR bond. That OR bond is going to be in the amount of the maximum possible fine of the highest misdemeanor they're charged with. So if it's a C, $500 OR bond, B, $1,000 OR bond, A, $2,500 OR bond. And the way you protect community safety is through terms and conditions, be they normal probation-esque like terms and conditions, like get and keep a job, stay in good standing in any academic program you're enrolled in, no contact orders, don't fraternize with anyone who's on probation or parole, don't acquire any firearms, don't consume alcohol excessively, don't consume alcohol in any amount. That's how you guarantee that the community is protected on most misdemeanors, not requiring them to post a bond, and if they don't, they can sit. For felonies, it's a more complicated issue for two reasons. One is that when an arrest warrant comes in, my policy has always been I try to synchronize my determinations of PC bonds with the eventual arrest warrant that I'm anticipating. So one of the issues we have with doing OR bonds on felonies is that other states complain when the arrest warrant eventually hits and it's got an OR bond. And I'm not gonna do an arrest warrant. I'm not gonna OR someone and then do a cash corporate surety bond on an arrest warrant. But so there is usually if they're charged with felony, there's usually a cash corporate surety bond. It's usually small. Generally speaking, again, on something that could classify for a clerk's deposit bond, I will usually make it a cash corporate surety bond in the same according to the same schedule I use for a misdemeanor. So usually if it's an 8 to a 10 non-drug felony, it's usually a $2,500 cash corporate surety bond. If it's a drug 5, it's usually a $2,500 cash corporate surety bond, and all with conditions. Beyond that, it gets more into beyond that, it's a case-by-case basis, depending upon the history, the exact nature of the offense. I've OR bonded someone way back when on a severity level 3 marijuana possession because with intent to distribute, because the officers asked that person, are you going to sell this quarter pound or half pound of pot that you have? And he said, no. Are you going to share it with your dorm mates? And he said, yes, which under our laws is possession with intent to distribute, but it's not really what the legislature intended, at least when the statute was drafted in the 80s, and it's not what you need a big bond to protect the community from as far as bad conduct goes. So to circle back around, I certainly believe that there is a presumption in favor of liberty in pretrial detention, and that whatever you do with bonds, whatever you do with conditions, they must be the least restrictive necessary to further the goals of the statute of preventing flight and protecting community safety.
How do you balance what you perceive to be necessary to protect the community versus the county attorney or assistant county attorney standing in front of you telling you that they need more? This is what we think is necessary to protect the community.
Well, the first step I would take in attempting to balance, I would ask the county attorney to expound upon that. It's, you want more to protect community safety. Give me numbers on what you think is appropriate, on why you think that is appropriate. What are your metrics on these numbers you're handing me? I am very big on asking for what people think as in terms of specifics rather than them asking me, hey, judge, just set a higher number, because I know my own understanding of what big numbers are is going to be different from what the state is of the opinion of. So that's the first step in balancing it, is asking the state to set what it thinks is appropriate and providing some analysis on why it thinks that is appropriate. And then to balance that out, I would turn around and give the defendant, why does the defendant think that it's appropriate? So, or inappropriate. So state, I do a bond, I do an OR bond of $2,500 on somebody for something that comes before me at first appearance, and state requests the bond modification that they basically make it $25,000, just to throw out an obscene number that I know Mr. Gale would never do. But, and my first question would be, all right, so why do you think this number is needed? And what's your logic behind how you got it? And then I would turn to the defendant and I would ask the defendant, how do you address the logic that the state has thrown out here, and see what happens? Sometimes there's a good logic behind it and a good reason for the request. There could be information that I don't have access to, that wasn't in the affidavit, and I don't readily have. It could be just a reflexive urge to protect the community by any means necessary, and that particular prosecutor, just, that's how they've always done it. It could well be that the defendant knows something that's relevant that means it's not an appropriate amount, one way or the other. Or the defendant could say something that says, yes, this is appropriate. I can pay this, and I think this is necessary to guarantee my attendance in court. You never know until they actually open their mouths. But I think the way you would go about attempting to balance it is you first start with how you would solicit information from anyone, get everyone's say, and then follow up with it by providing everyone an opportunity to rebut one another and ask whatever questions the court feels are necessary, depending upon the particular things that are said in the course of the inquiry into balancing. Which was rather roundabout, but did that answer your question, Zach?
Yeah.
Judge, I thought your application was very well written and very entertaining, which I appreciated. I noted with interest that you only had one letter of recommendation. I know there are more people out there that think you're cool than just one. What was your thinking behind limiting your letters to one letter?
Well, there's something to be said about quality over quantity. In all seriousness, though, in light of what happened the last time I came before the commission, I, for most of the application period, did not believe that it was worth my time to apply because I just thought the result would be the same as last time because I assumed that the combination of 3 people who had been previously sent up would apply and they get sent up and that would be that. A combination of some good word from discussions with people of some good words that were said motivated me in conjunction with the relative lack of applicants. When I had to make my deadline decision to apply, it would have been the Thursday before applications were due. 1 application had been due, and I would have kicked myself if I didn't apply and I could have, and only 2 people had. So to circle around to why only 1 person, everyone on at least the attorneys has interacted with Steve. And from what I understand, Steve is in good standing with you all. So I believed Steve would be he'd move the needle. And in light of the lateness with which all of this developed, there was the time crunch of simply putting together people who could do it. It was hard enough to get 1 on 3 days notice, let alone a whole portfolio. But 1 is still an improvement over previously. Previously, I had not ever submitted any letters of recommendation. So in the event that I am not sent up or I'm not picked, then next, when Judge Worst retires, you'll get your full portfolio, John.
I have, from conversations with you, I know that you are very happy and very satisfied in your present position. Can you share with us why you're applying for a change?
Yes, I can. 1 is that the things that I do and I can do, what I've built in Syracuse is good. It's nice. It's my little fiefdom, but I can help more members of the district, and I can make the world a better place, for lack of a better word, at least the judicial world a better place, by moving up the ladder. Most of what I do is scalable and can come with me, and I can do that in a way that leaves Syracuse well in hand by whoever replaces me will inherit a binder, about yay thick, of documentation of how things are done, where the skeletons are buried, what exactly exists, what passwords are, what the logic is for why things have been done the way that they are. And there are also ways to, how do I put this? I know all of the judges do not need to reside in Finney County. As 26th Judicial District demonstrates, you can have district judges out in the country. I'm not saying I would push for that, but it's something to, in the course of the coming years, as we evaluate what the district is doing and where it is heading, it is certainly something that can be looked at. And I could still potentially serve the community out here from here. And it might be worth my while to just commute into Syracuse, commute into Garden. In this age in which we live of remote technology, where you live and where you chambers matter much less than they did even 5 years ago.
Let me ask you this, Judge. You just answered, why I want the change, make the judicial world a better place. Prior to applying, it sounded to me like you were saying, well, it doesn't mean that much to me because I'm not going to get it anyway. And then you find out, well, hold on a second, maybe there aren't going to be 3. I'm going to throw my hat in. I mean, it almost makes it sound like maybe you don't really want it, but you thought you could get it. How do you reconcile that?
Because I hate talking about myself. I detest talking about myself. And this is an immensely stressful endeavor, summoning up and talking with all of you for 45 minutes to an hour about myself and my philosophies and my foibles and my good points. It was in the event that I thought I was not going to, that it was not worth the effort to go through that, when the outcome seemed preordained. I would have preferred to just avoid the heartache and the headache, and I would have preferred not to kill a small forest with the putting together the application. But how I would reconcile it is it's something that I want. But in light of what this commission said, and during its deliberations on the last time it had met, I did not believe that it would be worth the heartache and the headache to go through this only to not be sent up again as I assumed that 3 people who previously applied would apply for this position this time around, and the commission would do as it did last time.
You mentioned philosophy. Could you give me some ideas of what philosophically you would change with the Kansas judicial system? What changes would you like to see?
Well, do you have a couple hours? I can talk about anything anything that is what changes should be made, or would you like to make if you were given God powers for a day. Can I confine that to the district of more practical? What if I just could snap my fingers? What would I change?
Sure.
Firstly, one of the recurring problems that we have in this district is we keep running into technological walls. We do not have any kind of coherent or unified technology policy in this district. I would argue that a lot of it comes down to basically the mandate that we use Finney County for all court processes in all counties. I would say we need to implement our own court policies that are respectful not only of Finney County's desires, but of the other outlying counties to exercise their same sovereign rights and develop an institutional outlook towards their technology, not just everybody has to use whatever Finney County does in the name of standardization. I would further add to that we need to better address especially in the outlying counties, every courthouse needs somebody who's a designee of, if it breaks, do the basic preventative maintenance on it, because as it stands, we have cases where stuff is not checked. Hardware isn't routinely checked. Maintenance patches are not usually run. Technology problems are allowed to creep in and fester, and then they sit because we have one IT guy who's overworked because it's his job to attend to everything that's plugged in. I would also attempt to address the issues we have with bonds, because we do have radically different bonding practices that change not only from county to county, but even judge to judge in the same county. We do have a bond schedule, and part of our problem with how things are so different is that our bond schedule has not been really looked at since 2013. That is the signature date on the bond schedule. The issue has come up and it has promptly died the couple of times it's been raised. It's something that we really need to look at to try to either implement a uniform bond policy or revise our internal policies to make it clear that every judge is tasked with working with their county where they are based, and in terms of the district judges with the law enforcement in those counties to come up with a coherent bond scheme for each individual county and attempt to rationalize them between the counties to the greatest degree possible.
Any other questions?
I would, I'd like you to share, Judge, some of what I'd consider, at least to me, to an old dog, very innovative things that we have done fundamentally because of COVID, but as it turns out, beneficially, how we've dealt with drug felons trying to get back from West Virginia, South Carolina.
I will take a few props for being forward looking, because the first time I suggested using a remote appearance for a defendant was in November 2019 with regard to one of the individuals Mr. Gale was talking about. He was a gentleman in West Virginia who was never going to get back to the state of Kansas otherwise. Let's start with, as far as COVID stuff goes, the first big one is remote hearings. We have in Hamilton County, we have rolled out 3 separate AV cards in our courthouse. One's in our jury room, 2 are in the courtroom itself. One is a digital whiteboard, and the other is is a cart that has a computer hooked to a TV that we run our sound system and Zoom stuff off of. That allows anyone to come in and watch whatever we're doing on Zoom, which in turn has allowed us to adopt a policy of come as you may for non-evidentiary hearings or non-substantive hearings, where I'm of the opinion that so long as you show up, I'm fine with it, be it by Zoom or in person. We'll make it work one way or the other. As part of that, I spend a not inconsiderable amount of time attempting to help parties get onto Zoom and helping them troubleshoot their various issues, which I've become fairly proficient at, as I run both the front and the back ends of every Zoom hearing that we conduct in Hamilton County. I also have streamlined the scheduling. We send out an invite to every individual who appears remotely. We have them fill out a contact information sheet, for lack of a better term, whenever they appear remotely for the first time. So they've got email addresses, get those invites out to them as part of the process. Since we do first appearances remotely, we do allow them. There are some days where we'll have, if we have 10 people on, we might have 8 who appear remotely and 2 in person. And then there'll be some days where all 10 will appear in person. So it varies, but usually between a third and half of first appearances are done remotely in Hamilton County. We do full applications for counsel and waivers of right to counsel remotely. We have invested in an e-signing platform through HelloSign that, from my private practice experience, I found to be the most idiot-proof way of getting electronic signatures. We send them the waiver, they sign it, comes back, and then we just e-file it as is with the audit trail so that you can verify who was sent to and who signed it. At the same time, we have moved to using a web form for applications for appointed counsel, which we processed 55 to date in the last 16 to 18 months. So if somebody asks for appointed counsel, we just send them a link, they complete the web form comes back, it's reviewed, the necessary orders are signed, the cover sheet attached to it, so it has a caption on it, and it's filed. We've also moved to a web form for the diversion process. Their diversion form is now web form that is filled out, and it goes straight to Mr. Gale, and Mr. Gale then can review it and move it on down the line. We've also inboarded most of the order drafting in our criminal, and we inboarded all of it on our criminal and traffic matters. It's assumed at least I'll draft every order for every criminal and traffic hearing. Thus far, there have been 712 orders that I've drafted and filed so far this year that Mr. Gale or other counsel have not had to because of that. This includes forms for miscellaneous stuff for all prelim outcomes, for arraignments on both felonies and misdemeanors. Current project is expanding that to include sync stuff, which I realized how much I bit off when I looked at all 36 forms that are going to have to be converted over, but that is the nature of the beast. Hopefully by the end of the year, all journal entries in Hamilton County will be done by me, or at least the option to have them done by me. We also have been doing it in civil cases. I'm sorry.
So on a sync case, which is a civil case,
Mm-hmm.
do you have the attorney? Are you preparing it right there in the courtroom, and the attorneys are signing it while they're there?
Yes. Yes.
Okay.
Well, with miscellaneous criminal stuff, what the attorneys will usually do is they'll waive their signature on it, so I'll just sign it. But on dispositive stuff, I will either prepare it, print it out, they'll sign it, or I will send it out by HelloSign for them to sign, both of which we've done and has worked well. As another example of the stuff we've done COVID wise, we had a case where we had an indigent individual who was in a Sync case who wanted to do a voluntary relinquishment. Because of the need to do the voluntary relinquishment in front of a judge, there was some question as to how we were going to get it done when they were down in Guyman, I believe, or Liberal, no way to really get up to Hamilton County. We used Zoom to initiate the proceedings, used HelloSign to send the thing out, had them execute it while the Zoom call was ongoing to simulate it being done in front of a judge. And then when it got back, it was all good for me, and we got the relinquishment taken care of that way. So we've done remote relinquishments like that. There is so much that I could write books on the stuff that we've done and tried and why it's worked and why it doesn't. I'm willing to try anything. I attempt to think these things through as much as possible. I'll war game them. I'll mock them up. There have been a dozen things I've mocked up that have never gone anywhere because they just didn't work well enough to be worth trying to implement in an actual live court setting. But I think that is one of my great strengths, is that in this age in which we live of turmoil and the old way of doing court being washed out to sea, whether we like it or not, this starts from the ground up in a courtroom with conversations with counsel at every step of the way in trying these things, making sure there's buy-in, making sure there's feedback. Well, as Mr. Gale could attest, we went through probably 6 different drafting revisions on trying to get some of those prelim forms drafted and put together and demoed and working before they were ready for prime time. It because any change like this requires buy-in from the bar, and it requires that the court will have to provide some motive force and a willingness to do this, but we can't do it without the bar. And the bar's cooperation and what the bar wants is an important part of this. I mean, if Mr. Gale or my usual misdemeanor panel were saying, "Judge, stop this," I'd stop it, because it's not something I should cram down the throats of the parties and their attorneys.
Judge, if I'm reading your application right, you have a unique experience as in comparison to the other applicants, in that you have actually served as district judge on a pro tem basis for about 8 months in 2020. Am I correct on that?
Judge Woods did as well. All of the law trained magistrates were made district judges pro tem during COVID for the COVID period from April 2020 through the end of the year. Mine was particularly adventuresome because we had a first-degree murder occur in June. I did probably 40 search warrants, many of them electronic in nature. According to KBI, it was the first Facebook warrant they ever did. But so I had a fair amount of door knocking and warrant review during that time as pro tem. I made the option of just if our district judges who were assigned wanted to make use of that to dispose of stuff in Hamilton County, to do it. I think we dealt with maybe one civil case that needed to be done, just a journal entry done in that manner. Otherwise, Judge Pierce was quite happy coming out every month to do his regular dockets.
Okay. Was that a beneficial learning experience for you, do you feel?
I learned more about warrant jurisdiction than I thought possible during that, both in terms of what a district judge can do and what a magistrate can do, and more generally during that period of the exact boundaries between expanded magistrate jurisdiction and district judge jurisdiction, because that question came up a couple of times of, can we do this in front of you? Do we need to go to Judge Pierce? Is this something that can be done reasonably in the pro tem capacity? So I did learn a great deal about the complexities and limitations of jurisdiction, especially in the realm of warrants.
And Lucy, he rejected some.
Yeah.
Quick question in business litigation or civil litigation, what would your philosophy and or policy be with regard to alternative dispute resolution? Ordering it, encouraging, give me your thoughts on that.
All right. I will admit I've been watching all morning. I think Rick probably hit the nail on the head where I'm coming from on this. It's that it's a good idea. I want to encourage it. But if someone's coming in saying, I'd like to go, but there's no way I'll ever get authority, it's pointless to order it. It's just going to consume more money. I would also say that with regards to contractual terms, as far as ADR goes, because some contracts require it be submitted to mediation or arbitration before you can sue or before you can go to trial. I would say certainly those are enforceable and should be respected, barring whatever circumstances might exist where someone could make a legal argument that they shouldn't be. But parties generally enter into these things knowing what can happen. And I've seen amazing things in the domestic sphere happen with mediation that I didn't think were possible. There's no reason not to think that when you're just fighting about money, that the same couldn't happen. So I would certainly encourage it. And I might even, depending on exactly what the nature of the reticence of one of the parties is, I might even order it over the objection of a party. But if someone's coming, that's going to be rare. And if someone's coming in just saying, we're never going to agree because I can't get authority from my client, let's just set it for trial, I'm certainly going to do that, because automatically ordering it is just going to probably waste money if people are behaving in good faith and telling you what they're being told by their clients. You're muted, Lucy. Deja vu all over again.
I get kicked off, and then when it lets me back on, it mutes me by default. I appreciate your setup there, but I have to wonder, do you have a podcast or a vlog that we should know about?
No, it's a work in progress. A work in progress. As I stated in my application, there's some video projects that I'm working on. Some of the audio is recorded, but not much. Not all the scripts are done, and it's always a work in progress. But it's one of the things that I'm trying just on the side to see if it can improve the way we do things, because it allows us to distill information into a form that's more accessible to more people than reading some form that we put together. Make it available and perhaps answer questions of defendants prior to hearing. Whether it will or not, well, you never know until you try. And if it doesn't, then you keep working on it to fill the holes. Perhaps the hole is that it's not widely enough disseminated. Perhaps the hole is a bad take was done and the script was not good. But it's a process. And so what my goal is I want to just do some explainers about the equivalent, so that I can have online the equivalent of the 15-minute spiel that is the reading of the rights that is normally done at first appearances. I'd also like to answer some frequently asked questions, like, I routinely have to explain why people who are pulled over by officers, are OR bonded, and are given a ticket for misdemeanor marijuana possession. They freak out when they find they've been charged with no tax stamp. I would like to do a video that explains in 5 minutes how that comes about, so that perhaps they can find it beforehand, or if people have questions, I can just play it once for an entire room, that video, to answer that question, so that if multiple people have it, I don't have to give that explanation multiple times or inquire if people understand, because I've already addressed the issue. The same goes with, I'd like to do a cut of the reading of the preliminary examination and trial rights to expedite preliminary hearings, not just say they're here, go watch them, but so that I can queue them up play them and know that they're recorded, say what they need to say, and I can not have to worry about hitting every note on the record in those proceedings. To automate some of the stuff that I do when we're doing the pro forma stuff that we have to do to get some of these cases resolved. At least that's what my goal is. Whether or not it will ever work, well, we'll see. It's still a work in progress.
Anything further? Well, hearing nothing, CJ, thank you very much. I'll give you a chance to just wrap up before we conclude for the morning.
Yes. I really wish I had something as good as the Churchill quote from the last time I was here, but as Mr. Cleaver was not on the commission at the time, I can sign off with that again. In a letter from Winston Churchill's future private secretary to one of his former paramours, he asked if he should take a job with Winston Churchill, who seemed to be prickly, obtuse, a know-it-all, and a blowhard. And this former paramour stated in response that he absolutely should, because Winston Churchill's flaws are immediately visible, and you see all of them at once. You learn his virtues every day, every time, in every additional meeting that you have with him thereafter. I feel that applies to me a fair bit. I am a little rough around the edges at times, a lot of unconventional, but I believe I'm good at my job, that I work hard, that I bring assets to the district that would be of use as district judges. And I hope that you see that a little more with every time we get together. So there's nothing else, then thank you all for having me. I know you guys do a ton of work and you hear a ton of sales pitches. Your time is greatly appreciated, and as is your consideration in this matter. So I will leave you all to go get lunch. I'm sure you're all hungry.
Thank you very much. Based on our agenda, we're ready to adjourn for lunch to come back at 1:30. Anybody have anything to bring up before we do that? Hearing nothing, again, well, Shelby, I guess help me here. Is it better just to continue to mute and stop the video and let things run as opposed to getting back on?
Yes.
Okay. So if you just want to do that, that'll be great, and you'll be right back in. We'll see you at 1:30.
Hey, guys.
Hey, Rob, what do you know?
Oh, just paying that civic rent today, big guy.
Yeah,
Did you go boating this weekend?
no, I've actually been recouping. I had cataract surgery on both eyes.
Oh,
And that's why I can see without glasses now. So
wow.
for the first time since grade school. So
So did they do that little laser thing too?
no laser deal. They go in and I don't know to explain it. Marilyn watched the procedure. She could tell you, but they take out the old lens that's got the cataract in it, and they replace it with a basically kind of like a contact lens that fits your prescription.
Wow.
So yeah, it's great, but the process isn't fun going through a couple of weeks of eye drops and all of that misery, but it's pretty nice once it's done. So
Yeah, I bet. Wow. Well, at least it went well.
yeah. Oh yeah. Well, Dr. Fry is officer there. That's quite the place. So
Yeah, that's a wonderful asset for us to have out here.
yeah.
Absolutely. Well, hello, Justice and Shelby.
Hello.
You.
Are we YouTubed again yet, or are we?
We are.
Okay.
Oh.
Then I'll watch what I say. It's an exceedingly difficult task for me.
Shelby, I know Christine doesn't have a block up. Is she in the waiting room by any chance?
It's not, no.
Okay.
Better way to do that. Oh, where am I? Yeah, we are.
Hey, Luce,
What?
how
It's
come
Steve,
you never are in the center of your screen?
because I can't take notes if I'm in the center of my screen.
Okay, well, you were questioning and I was eagerly wanting to hear what you were saying, and I was only seeing your left eye at one point.
Good.
Hey, Rob, has your hair always been that white?
No. I had a near-death experience that, in fact, do you want to buy a haunted house?
The price is right.
Well, it would be. If I can just show it to you.
Not if it's going to do that to my hair.
And I kind of like your former partner to come along.
We'll let him drive.
There you go. Somebody better drive, but I'm not sure it's either one of you.
All right, well, we're all reconstituted here as the nominating commission. We've got one more interview with Nicholas Verana. And after that, we'll, have we had any notice, Shelby, about public comments? coming in?
No,
Okay.
no.
Well, we'll see what happens at 2:15, and then we'll be able to move into deliberations and a vote. So does anybody have anything before we bring in our next interview? Not seeing anything. I go ahead there and
I will bring him in.
well, welcome. Can you hear me okay?
Yes, Your Honor.
Well, we're coming back from lunch break. I'm Dan Biles. I'm a member of the Kansas Supreme Court. I'm a non-voting member of the commission, and we have a 45-minute time span set aside to interview Nicholas. Is it Verana? Am I pronouncing that right?
Yes, Your Honor.
Okay. To interview him, and what we'd like to do is just let you open things up with a little introductory statement, maybe explain why you think you're qualified to do the job, and then we'll break into questions.
Thank you. First of all, thank you for considering me today for a position as a district judge in the 25th Judicial District. I'm a person of integrity and competence who would serve the citizens of the 25th Judicial District well. I have both prosecuted and defended criminal cases and understand both the need for crime victims to receive justice and criminal defendants' rights to be protected. I have represented both plaintiffs and defendants in civil cases involving business disputes, personal injury, and contracts, and understand the competing interests of parties and the need for both to achieve justice. While I have little experience doing family law matters, I have personally experienced the effects of divorce as a child. I think that can substitute for some of my lack of experience. In litigation, I have drafted, responded to, and argued many different kinds of motions, including motions to suppress, motions to dismiss, summary judgment, motions for attorney's fees, Daubert motions, and motions compelling discovery. I've tried over 20 jury trials, numerous bench trials, and in my experience, I've become very familiar with the rules of evidence while conducting both civil and criminal litigation. I believe this knowledge and experience makes me a well-rounded candidate for a position on the bench. Additionally, I've been a member of the Army Reserve or National Guard since I was 17 years old. Prior to going to law school, I spent 9 years on active duty. And I sort of went to law school as a non-traditional student when I was a little older. But I think my military service provided me an excellent foundation for my legal career by encouraging thoughtful analysis and sound decision-making. When you work for senior military leaders, you have to be very particular about the advice you give and the analysis used to get there. Additionally, the military also taught me that you have to have courage when making decisions. I remember one incident where a battalion commander was advised to avoid a certain course of action because it could result in complaints against him and ultimately hurt his career prospects, to which he responded, I'm not going to let a little thing like my career stop me from doing the right thing. It's things like this from my military career that have stuck with me and reinforced the need to have courage to do the right thing. If I'm appointed, I would be a judge that carefully renders decisions and gives due consideration to all parties before me. I do understand the immense power conferred on judges, but recognize it must be exercised consistent with the law and the limited role of the judicial branch in our system of government. I can assure you that I would exercise judicial authority in a fair and impartial manner according to the law. I'm honored to be here today and ready to answer all of your questions.
Thank you. And with that, we'll open it up for questions.
And left. Are you comfortable with the idea of moving back to the 25th Judicial District?
I'm actually very comfortable. When I went and spoke to my wife, who's from Hayes, about applying for this position and moving back out there, her response was basically, can we start packing now? And so I am very comfortable. It's why I applied for this position. And I enjoyed my time in Garden City. It was just I think both a financial decision and a decision with work prospects for my wife and her going to school that necessitated the move back to Kansas City.
What unit do you currently drill with?
I am with the 35th Infantry Division, Kansas National Guard out of Leavenworth. I'm actually going to be submitting my retirement paperwork here shortly. I was supposed to deploy come January, but we found out a couple weeks ago that my wife is pregnant. So I'm going to be taking the opportunity after 23 years of service to retire. I think my wife's comment to me was, I'm not doing this by myself, and I don't want to ask her to do that.
I don't want to cause you any trouble, but I am curious. Were you in the Douglas County DA's office under the prior district attorney?
No, I was not. I was hired in March of this year by Ms. Valdez.
Well, I assume you realize that at least perception wise, that's quite a philosophical change.
No, I do understand that. I often explain to people when I was assistant Finney County attorney, it was very different the way things were done. And at the end of the day, when I work here, I'm a loyal soldier. So the boss says this is the policy, I follow the policy. And my boss also understands that if I got to pick the policy, that would not be the policy, but I'm not the elected DA, so I don't get to pick the policy. And I just follow it and do my best to adhere to what she wants.
What policies does she implement that you see value in implementing or trying to persuade folks to go that direction if you were a district judge?
Okay.
And just a minute, am I correct for the other folks that you no longer prosecute small marijuana possession cases?
We do not. We still prosecute distribution. We do not prosecute marijuana cases. And I think that was a continuation from the prior administration. As a judge, that wouldn't really be my call, because it's not the job of a judge to exercise prosecutorial discretion. That's at the hands of the prosecutor. But a lot of the policies that we have here are based around services in the community. So instead of cash or surety bonds, we do a lot of pretrial release here, where we have basically like probation officers that supervise people. I doubt that would be a possibility given the spread out nature of the judicial district. And it requires a lot of resources. There's some other things, like we have a mental health court, behavioral health court. But again, that's all tied to resources in the community that's funded by the county. It's not really something that the judiciary can just implement without the participation of various stakeholders. It requires, the participation of not only the judiciary, but the prosecutor, defense counsel, because those are voluntary programs, much like our drug court. I don't handle any of those at this time. If one of my cases gets referred to those, they go to a different prosecutor. So I'm not sure any of the programs we do here would necessarily translate, given the different population, the spread out nature geographically of the judicial district, and just the different amount of resources available.
Thank you.
Nick, what changes would you make in the Kansas judicial system? And just from a philosophical overview, what changes would you make if you had that opportunity, or that you see would be useful?
Well, some of the I don't really care for elected judges. So I know this judicial district, the 25th, doesn't elect judges, but some do. And I was talking to my aunt, who's a municipal court judge in Colorado, and we were talking about how electing judges can create some, bad results, and so I don't think it does a good job of screening candidates. I don't know that I would make any philosophical changes. Other than that, I don't really see any need for drastic changes.
There's been a big change in the approach to setting bonds. In criminal cases, a lot more use of OR bonds, or like you guys do up there, it sounds like a pretrial supervision in lieu of a bond. What would be your judicial philosophy on that? And if you can delineate between misdemeanors and felonies.
Well, I think my philosophy is you have really two reasons for setting a bond, right? To assure their appearance in court and to protect the public safety. And so that would be sort of my philosophy. You don't need to keep people in jail simply because they're charged with a crime to sort of coerce them into any sort of action on their case. But I've also seen, so as I talked to Mr. Gale about, we do a lot of pretrial release. I have a case right now where a guy has 5 stolen bicycle cases, and then he rode a stolen bicycle to his appearances, picking up a 6th stolen bicycle case. So at that point, you kind of have to look and go, okay, how are we going to stop this guy from stealing more bicycles? And is this a guy we're going to now, instead of putting him on pretrial release, say, hey, you're going to have to put up some money to get out of jail, or are we going to put you on some sort of GPS monitoring, which seems like a very intensive way of doing it for somebody who is charged with property crimes. But at some point, you just have to look at it and go, are they showing up to court, and are they a risk to the public? So that's the way I would look at it. And, with misdemeanors or felonies, just because somebody's charged with a misdemeanor doesn't mean they're not a risk to the public. But at the same time, not every felon is automatically, or alleged felon is not automatically a risk to the public. So you have to just look at the individual facts of a case and decide, is this person going to show up, and do they present a danger?
Shifting gears on you, what's your guys' use been of Zoom to do hearings? And what's your philosophy, I guess, on allowing witnesses, particularly expert witnesses, to appear remotely by Zoom for trial or evidentiary hearings?
I have no general objection to doing evidentiary hearings by Zoom. I have done some. Depending on the state of the connection and the participant's ability to navigate Zoom, that can make all of the difference in the world. The real problem you have with Zoom hearings are the delay. So people start talking over one another. People start arguing. There's just this delay. So I think you have to look at it as it's a great tool. And depending on the nature of the case, I don't see any reason why we can't do more of it or we shouldn't do more of it. I mean, we do most of the stuff here is all by Zoom. In my last, before I took this job, I was doing civil defense work, and Zoom was a godsend for us because it drastically reduced the amount of travel we had to do, because I had cases from St. Louis to Goodland. So not having to travel. So I like Zoom. I just think you have to be careful with it and make sure everybody doesn't let the technology and the delays in the technology create a mess for making a record and just general control of the proceedings.
Nick, career-wise, where do you see yourself in 10 years?
Hopefully on the bench. It's kind of the job that I've kind of wanted since I graduated from law school. I know I talked to a lot of people that don't want to do that job, but I couldn't see myself voluntarily leaving that to do something else. And if I'm not doing that, I'm probably going to be a prosecutor for the foreseeable future.
Nick, you had mentioned that y'all are doing Zoom for just about everything. Have you done jury trials or anything like that?
No jury trials by Zoom. We just started jury trials back up, I want to say April or May. And I think jury trials would be the lone thing you probably could not do by Zoom. I think there's too much temptation for jurors to do their own research and look at stuff and do stuff they're not supposed to if they're not in the confines. But I've done bench trials and preliminary hearings, evidentiary hearings, all by Zoom. So I think that when I say most everything, everything except for jury trials, we do a mix here of in-person and Zoom hearings. But I know like all of our dockets are by Zoom, and I don't foresee the judges here ever going back to having everybody pile into the courtroom for an hour each week to get through all the cases.
As far as family law matters, I think you and I might have had a couple of cases, family law matters, when you were out here. And of course, that's something that I'm very interested in. Some judges have kind of hard and fast rules, all things being equal, I'm going to do 50-50 shared residential custody. Some judges say, you know what, kid's going to have a home. I'm a standard plan guy or gal. And then there are those that are totally unpredictable. You and I both know that given that there's so much discretion in a custody paternity case, it is nice to have judges say, this is sort of my tendency. Have you put together any sort of your own, hey, this would probably be my tendency in a custody visitation case with a couple of good parents in the same town, all things being equal?
Well, if my thought would be that both parents, if they're good parents, deserve equal time. I can't say that that would be every case, but I can't see. Okay, I'll just tell you for me. When my parents got divorced, I got one weekend every other weekend and 4 weeks in the summer with my dad. That's it. Okay. And I often felt, the one person nobody ever asked what should happen or what would like that was me. And so I feel like when you do custody stuff with, well, the kid's gonna have a home, and then they're gonna see the other parent, the other parent's gonna have parenting time on a certain schedule. For me, I think you're almost taking away too much parenting time from one parent. And I think children are more resilient than we give them credit for. And so while I can't say that it would be, oh, I'm a every other, I'm a 50-50 guy all the time, but I would say that based on my experience and also the experience I have with my stepson, that I can't see anything but a 50-50 being the most fair way to do custody.
Some judges absolutely refuse to interview children. And obviously you're taking the child's age into consideration, but some judges say, I'm not going to interview a child. I've never heard anything from a kid that could persuade me one way or the other. There are other judges that say it's extremely helpful. You just indicated that you were the only person who wasn't asked. Do you think you would be apt to, depending upon the age and maturity of the child, that you would be apt to want to interview a child?
I think I would. I can't say that it would be in every case, because I think there's good reasons in some cases not to. But I just feel like the kid in a custody situation, the kids given based upon their age and maturity, they don't get to decide. But I can't see any reason not to at least hear what a kid has to say unless there's a good reason not to. And I mean, it's not, you're not asking a kid, hey, which parent do you like more? But you're more getting a sense of how they feel and what they think of what's going on in their life. And so I think I would be more apt to want to hear from a child than not.
Thank you.
Any other questions?
I'll take a stab at one. Nick, and you've done civil litigation on both sides. What are your thoughts on alternative dispute resolutions in, say, business litigation? Examples have been used where lawyers will say, I have zero authority from my client, ain't gonna happen. What are your thoughts in situations like that about ordering it anyway?
I always, as a civil litigant, in those tough cases, I always liked it when a judge would order it, because I could go back to my client and say, look, we don't have to agree to anything, but can we just hear what everybody has to say? And I think it just gives you some juice with those difficult clients. That being said, I don't ever believe a judge should force a settlement. So what I have seen work best is in those cases where parties come in like that. Oftentimes, I don't think I'd be one to order an ADR, but sometimes the attorneys will tell you, "Hey, my client's sort of not really wanting to settle, but I think ordering a mediation to get them to at least think about this would be a good practice or a good thing to do." And so I think as a judge, you have to listen to what the attorneys are telling you about the prospects for settlement. Because if both parties come in and say, "Look, this was the worst business deal that either one of these people have ever done. They hate each other. There's no way to get it settled. And if you order mediation, you're just asking our clients to throw money in a hole in the ground and bury it," then I probably wouldn't order it. So I think everything you have to look at the individual case. But I think even in some situations where you have clients or parties that are reticent to enter into settlement, I think in some of those cases, ordering mediation can be helpful because it will actually make the parties think about their position and have somebody that's neutral challenge their position. So it's not just, they're not in their own head convincing themselves of the righteousness of their own cause.
I have a question. Okay, looking at your application, you seem to move fairly often. If you get this position of judge, do you think you would stay here many, many years?
Absolutely. I couldn't see myself moving anywhere else. Like I said, my wife wants to go back to Western Kansas. We want to live out in the country. We own horses. It's honestly the perfect place. And I think a lot of my movement prior to going to law school was the Army. So I was stationed in different places. Then I went to law school. Then I moved out to Garden City and then moved back to my house in Kansas City that I was in law school. So I think if I were appointed to the bench, I don't think I would go anywhere else unless the voters of the 25th Judicial District decided I was no longer qualified to be a judge.
Got a question. What's your philosophy on following plea agreements? Or do you think the judge should very seriously sometimes go against them, reject them?
I do not following a plea agreement ought to be the exception, not the rule. And it ought to be for exceptional cases. And the reason for that is our system is dependent upon cases being resolved. So without incurring the time and expense of a trial. So when, let's say a criminal case where the prosecutor and the defendant come to an agreement about what the charges should be, what the sentence should be, why should a judge, absent some intervening circumstance, say, "No, I'm not going to agree to that"? Some examples, a person gets a plea agreement and then just doesn't appear for court, right? And gets a bench warrant and has to go out. And then, we pick them up 6 months later and they're like, "Well, judge, really, follow the plea agreement, put me on probation." Well, the judge should have to consider that there's been an intervening circumstance, right? Now, if everything goes according to plan, I don't see any reason why plea agreements should not be followed in 99% of the cases, because that's what the parties have said is acceptable to them. And as a judge, what is the position of a judge to say, "No, that's not an acceptable resolution," when those involved say that's acceptable? So I would say I would not, that would not be anything I think anybody should be worried about if I were appointed to the bench.
Anything further? Well, if not, Nick, what we'd like to do is have you do a little closing argument, if you will, closing statement to wrap up your interview, and then we'll move on with the remainder of our agenda.
Thank you. I would just say that as I said in my opening, I think I'm a well-rounded candidate. I think I would serve the residents of the 25th Judicial District well. I have experience in a multitude of different fields in litigation, and I just believe that I would be the best person for this position based upon my past experience, my military experience, and my ability to, learn and understand the law. So I would just ask for your consideration for my nomination. Thank you.
Thank you, Nick. We'll go ahead and excuse you and put the commission together here. So because the agenda has public comments at 2:15, and we haven't heard anything still.
No.
But I don't want to cut that off. So we've got a couple of things here. We can take a 10-minute break, come back in at 2:15, see if we have any public comments, and then move straight into deliberations, or we can start talking now and then break at 2:15 to see if we have anything. Stop at 2:15 real quick to see if we have anything. It's completely up to you.
I would like one thing to be addressed quickly. Bill sent out an email with a statutory reference that, in my mind, if you read it, indicated that if there are sufficient qualified residents of the district, that they should be appointed. Has anybody got any thoughts? Is that being interpreted, or does anybody disagree with what that says?
Typically, I had a conversation about that I guess on Tuesday for another nominating commission that another justice is doing or did do yesterday. But anyway, the notion is it's your option. When you have 3 resident applicants, you don't have, in other words, you do not have to interview or consider an out-of-district candidate, but there's no, you can read into that what you want, Rob, but there's nothing in the statute that says you ought not to go outside the district if you've got 3. It's just giving you the discretion that if you wanted to not have the interview or not consider them, that you have that discretion.
Okay, I will tell you that is one poorly written statute.
Yeah.
As I recall, doesn't it have like a double negative or a triple negative in it?
At least a double negative, and I would submit triple.
I was sharing with Bill Heidman that it looked to me like a sentence had been completely left out between the first sentence and the second sentence of the statute. So yeah, it's very confusing.
I would definitely agree with Justice Biles that we can interview them and we can appoint them regardless of where they live at the time of application. I think our duty is to nominate 3 qualified applicants, and the qualifications are set out by statute. And being a resident of the district at the time of application is not in that qualification statute. And in fact, it was amended in '99 to state that to add they shall be a resident of the district, and the portion that was added said at the time of taking office. So to me, that's clear that we don't have to have an applicant be a resident of the district at the time. So I think we can appoint Nick if we choose. And I would point out that back in the 90s, this commission sent Tom Richardson to the governor, who was not a resident of the district. And there was more than 3 at that time. I know that Jim Mills and one other resident of Finney County that was a lawyer applied, and they didn't get sent, but Judge Richardson did.
I remember Mills went to the governor with Richardson. I don't remember if anybody else was on the slate.
Well, you would know, John. I was like in junior high then, so.
You have gotten a little smarter since then.
I have a query from somebody wanting to know how to submit public comments.
Well, we
I
don't
think
have,
Just send, do you have the, if you have the email, just send them the link and they can get on at 2:15. Or they can send you the comments by email and you can read them, either one.
So is it the YouTube link that they're getting on?
The Zoom link with the password, they have to use the password to get on.
Okay.
Justice Biles, I don't think the public has the Zoom link.
No, but we can send it. The
Yeah, I
idea
can-
was that someone would request. to-
I can send, Lucy can send it and they can do that, or I can send something to Lucy and whatever
send-
works.
You could write it on a whiteboard and put it on YouTube.
Started to sound like a ZZ Top tune there for a minute. You can put it on the, I don't remember it. Bill, you'll have to take it up from there.
I'll bet Zach doesn't remember that either.
Nope.
That's for later.
If people want to submit comments on the YouTube page are shut down, can they email them to someone? Because they may
can
not
email
have.
them. They
to
can
some-
email them to me, Lucy.
Can you give your email address so people that are watching on YouTube can submit comments if they want to?
I can. Justice Biles, is that what you want me to do?
It's fine. I mean, it's awkward when we're doing it this way but we can't just let people in. We have to know they want in first, and then they would get in the waiting room and Shelby would let them in if they wanted to speak face to face. But if they just want to email their comment, then your email's just fine, Shelby.
Okay, I'll go ahead and put it in the comments then if that's what we're gonna do, Lucy.
Okay.
And we've still got a few minutes before that official time, so we're fine.
Maybe, let's see here. I don't know that the comments work on YouTube when we're on
That's what
here.
I wondered that, Shelby. I think it's better just to give it out.
Yeah.
So
Lucy, can we send the Zoom link and password information to the person that's inquiring, and then we can admit them in to make their comment?
I sent it to them. I'm waiting to see. They may have been asking for someone else though.
I got an email from a person, I believe maybe with the 25th Finney County, and they asked if the YouTube comments are active. I said, I believe they are because I saw them type on there.
So I'm being told that they're not active.
There's an individual named Alfredo Galvin who typed in test on the comments on YouTube. He's the individual that emailed me.
Maybe they were turned off during the interviews, so now they're on.
There's been a second test on the comments page by Susan Richmeyer, so they can type on there.
Okay.
Well, it's hard to know how long to pause here if they're able to make a comment on the YouTube thing and we're not getting anything.
Yeah, you know what? I don't really have control on how to make the comments available if people are saying, you know, I got another email that says have people use the chat feature. I can't really do anything on my end. I think the Supreme Court YouTube is set up to where maybe these things can't happen.
It's got a live chat.
But the public can obviously type in a comment if they're wanting to.
And then you could relay it.
I would be glad to.
That's what I'm saying.
Mm-hmm.
Because I can't, because I'm not on the YouTube channel, I'm on the Zoom.
I have another comment on the YouTube that says I can add a comment and see Alfredo and Susan's comment. It's set up to where maybe these things can't happen.
It's got a live chat.
But the public can obviously type in a comment if they're wanting to.
And then you could relay it.
I would be glad to.
That's what I'm saying.
Mhm.
Because I can't, because I'm not on the YouTube channel, I'm on the Zoom. So now it's repeating back.
That says I can add a comment, see Alfredo and Susan's comment. It's set up where maybe these things can't happen.
It's got a live chat.
But the public can obviously type in a comment if they're wanting to.
I mean, you can relay it.
I would be glad to.
That's what I'm saying.
Mhm.
Why don't we take,
I'm not on the YouTube channel, I'm on the Zoom.
Justice Biles?
And now it's repeating back.
It says I can add a comment.
Somebody's
I
got
don't know why
YouTube
it's
open.
doing that.
Hey, Lucy, mute your deal.
Somebody's got their mic on and doing YouTube as well. Isn't that the delay we're getting?
Right, exactly. Who's watching YouTube?
I am, but it's on another computer.
I've got it on another computer. And you look really good on YouTube, by the way.
I do?
Yes. It may have something to do with the distance you are from the camera.
This is live.
Justice Biles, I'd suggest we take maybe a 5-minute break, come back, and we'll have whatever questions we have at that time. That way folks have a little time, but we're not just sitting here for
Yeah.
waiting for Godot.
Yeah, let's do that. Anyone who wants to make a comment can put it on that comment section in YouTube, I guess, or email one of the commission members, and we'll go from there. And we'll come back at 2:25.
Thank you.
email with a question to anybody? I didn't.
I'll double check.
I felt bad that after me.
Hey, Ralph. Ralph,
Yes, sir.
how do you blur the background and keep your face? Is that a button you push?
Well, if it was, I've forgotten it.
It's kind of cool.
I agree. And all the county maps and the different things hanging in my office, I figured nobody wanted to see that. If I had some nice looking background, it'd be different, but
For Rob's benefit, can you reverse that to where it would blur his face?
John, I almost showed up with a full face mask after your comment on the email the other day. Didn't do so. I can do this though.
Come back. Come back.
It's nice to be missed.
Well, and that, did we get any comments during that pause? I went to the YouTube channel and it's on a delay. I've got it muted, but there aren't any additional comments that I can see other than.
Nothing on my end.
So did anybody get anything? Any emails or anything?
We did not.
Okay. Then I think we can move into deliberations and discuss to your heart's content.
Justice Biles, I'd be, and not to put anybody on the spot, but I'd sure be interested in hearing what the non-lawyers have to say. We had some good interviews there, and I'd like to know, kind of what their feelings are. Ralph, you want to start?
Sure. At least the applicants that have appeared before us previously seem pretty status quo in terms of their answers. I was intrigued by responses to questions that had been submitted this time that hadn't been previously asked. I thought they all did a decent job. I probably share some of the concern about the more transient applicant that would come back, although I'm convinced by his answers that if he were chosen, he'd be here to stay for a while. Seems like we've convened quite a few times of recent to fill positions, and I think there's some merit and some consistency if we get someone that would be willing to stay. So didn't really have anything that I would kick anyone out about. So
This is Tim, and I'd comment that being a layperson and not having the opportunity to work with any of these people, I felt like all of them were well qualified, but probably on my list of the picks, and the top two anyway, I had Richard Marquez and Christopher Veliz.
This is Walker. I thought that all were good candidates, interviewed very well. And being the first time doing this, it was a great experience, and look forward to working with you all for many years to come. But like I said, I think good applicants and can't really go wrong anywhere.
This is Christine, and I guess I have a different perspective this time because I've gained a little bit of legal knowledge. And over the last few months since I've started this and kind of have a different perspective this time. But at the top of my list, I had Marquez, by his resume, by his interview today, and just basically by his answers. And then I kind of ranked him from there, but that's the top of my list.
Okay, and I will say I was concerned about Nicholas Varana because he has moved so often, but after listening to him, I thought he would probably be okay. And I thought Rick Marquez was good. Those were probably my two top picks.
The rules are must send 3,
Yeah,
may send however many. Is that correct?
3 to 5.
Okay. This is really, in my mind, kind of unusual, and anybody have any objection in sending 5? Because
Yes.
Yes.
Okay.
Can I say something as an attorney who practices in these outlying judicial districts? We have such a hard time filling vacancies. And I can tell you, Tim is exactly where he needs to be right now. We need him in that position. And he handles that position better than anyone else could, I believe. CJ is one of the smartest people I know, but he does an excellent job of keeping Hamilton County technologically online. He is innovative out there. How do we replace CJ if he becomes a district judge? And I'm not saying that these people should be penalized because they fit well where they are, but I'm saying realistically, we have to look at how difficult it's going to be to replace them and the qualifications of the people that we will be looking to do that. I am also concerned that they are both fairly young magistrates and don't have the years of experience that the other applicants bring. My understanding of Nick's situation is that he owned a house in Kansas City that he lived in when he went to law school. He came out here and practiced here for a while, but still owned the house in Kansas City and moved back there. So even though he had a couple of jobs after he moved back to Kansas City, and I may be wrong in this, this is just what I thought I understood from what he said. He worked in the private firm and then the county or the district attorney's office, but probably still lived in the same house. Or that was the impression I got. So that concerned me a little bit less since it was property he already owned.
And I 100% agree with Lucy. And there's no sense for me to even say another thing. I 100% agree with everything she just said. And I appreciate your comments, Lucy.
I don't agree 100% because I do think it's penalizing someone who is doing a great job in their current position and then not considering them for an advancement because of that. Focusing on CJ Velez, I think he absolutely hit a home run today. And you can tell he does not have the kind of ego that is going to get in his way, either in his current position or as a district judge. He's intelligent, pragmatic, and compassionate in the way he deals with the people in his role as a judge, and that will be exemplified in his role as a district judge. He's a really smart and sincere guy. I think that comes across. The innovations that he's made in his current role are impressive. I think he's clearly, his head is on straight, and I think he would be a absolute credit to the bench as a district judge. And I don't think we ought to shirk our duty in considering him, because we would have to reconvene and pick another magistrate for Syracuse if he got the job. As I said, I think he absolutely hit a home run in his interview today, and I think he should definitely be one of the ones that goes to the governor. Now, that said, I don't know what format we want to follow here. Do we want to, if we want to talk about individual candidates and then move to the next one, we can do that, or I can go ahead and say what I've got to say. Chairman Biles, do you have you have any input as to how you think we should proceed?
Well, I've got a few comments, and I think if we send Marquez and Brana and Sherwood, we're sending 3 people who have tried cases, who have litigated a lot of cases. I don't think that Judge Velez or Judge Woods have done that. I think they have a different level of experience. I think they're both very book smart. They're both very intelligent individuals. But in my opinion, they need some more time to gain some of that experience before being a district judge. So
I do got a question to both you and Lucy. How do those two, get the experience of trying cases when we want to leave them in a job they're doing well? I think that strikes me as just not realistic. And in the past, we have articulated that we'd like to see somebody as a magistrate so we know whether they end up with rogue disease. I can't speak to Judge Woods, but I hear good things, but I really don't know. I don't do enough there. But CJ does not have that problem. Nick Verana interviewed extremely well, I thought. I was really impressed with him. And interview-wise, he'd be somewhere in the number 2 category as far as I was concerned. Probably he and CJ were the most impressive number 2s. Rick seemed to come to the top to me. But I don't, as much as I hate to see another change in Hamilton County, I don't think we can ask people to go take the magistrate job and then tell them they're stuck. Because otherwise, whether Woods and CJ say to heck with this, I'm going to private practice, we're going to lose them anyway. You know, the magistrate job is not very rewarding financially. And I don't think you want to tell a qualified candidate they're stuck. So I don't buy the 100% on Lucy. And those are my thoughts. And that's why I thought, frankly, all of them were qualified, though I did not think today Judge Woods interviewed very well. He in my mind, got off into being the chief judge and all that, which, you know, now's not the time for that. So that's my 2 cents.
I don't think anybody is going to be stuck though, because we have two positions that are going to be opening up, one within the next few months and another one within the next couple of years at the very latest. Nobody thinks they're stuck. And some of this is selfish. We've gone through so many magistrate positions lately that having magistrates that are a joy to practice in front of is a wonderful thing. That's why I prefaced it by saying, as an attorney who practices out in the outlying areas and appears in misdemeanor court and cinc court, it has been a joy to practice with those two magistrates. I am certainly not suggesting that I think they're stuck there, nor denigrating their ability to move up, nor saying that I begrudge them the opportunity to. I enjoy having them where they are. They're wonderful to practice in front of. I think they still have more to accomplish where they are.
With CJ too, he admitted his reluctancy to submit his application, and then also mentioned about still living in Syracuse and commuting over, which I don't know if that's allowable or whatnot, but to me that seems like that he enjoys it there in Syracuse and wasn't 100% committed once it was able to submit an application and didn't do so.
That is allowable. He could absolutely get the appointment and stay in Syracuse as long as he's living in the judicial district. So that's going on in other judicial districts now. So that's not a problem.
And just to add to that real quickly, the only awkwardness is back in older times, judges made that commute and they submitted their mileage and got reimbursed for it. And that's probably not going to happen with the newer judges. So this is not an election. I mean, he can elect commute. That's not a problem. The issue is whether you get to charge the state with it. And so that'll be something that's to get worked out with the court, actually, in terms of where we designate his office. And I'm not trying to speak against it. I'm just saying that used to be more automatic than it is now.
I'd go ahead and make a motion to nominate Marquez, Sherwood, and Brana.
Second.
I just want to make sure I've got the motion. You were Sherwood, Marquez, and Varna?
That's correct.
And I had a second, right?
Yes.
Yes.
Okay, so we've got a motion and a second. We can now have further discussion. When we get to a point where we're going to vote, I'm going to have you show your hand so we can see it on the screen. So, but anyway, we got a motion and a second. People can speak to the motion.
I am not going to be able to vote on a slate of people that involves my law partner. So I would prefer that we vote individually. I understand I'm not in control of that. It's just an expression of my desire. As far as the two that are on that slate that are not my law partner, I would strongly urge the commission, and nothing against Nick. Nick was impressive today. He is insightful. He brings the perspective, an important perspective of a child going through a divorce to the bench, and I thought I was very impressed by that. Nick was good to work with. I had civil cases and criminal cases against him while he was here in Garden City. He was good to work with on both sides. We've got qualified candidates who already live here. I just tend to favor them. And rather than Nick being one of the ones that goes to the governor, I would strongly urge the commission to choose one of a proven judge who has accomplished good things and that I've already talked about, and that's CJ Velez. So that's my 2 cents worth on that. I agree on Brian Sherwood being one of the ones that should go up. He's steady. He's been promoting the public interest for 30 plus years, and at the same time dealing with people from all walks of life and being fair to them. He's level-headed. He's got good character. He's got good depth and good insight, and he's got the right disposition to be a judge. So I absolutely believe that he should agree that he should be one of the ones that goes to the governor, and I think CJ Velez should be.
Zach, out of respect for your motion, I feel like you're the one that's going to have to modify it if you want to respect John's problem about voting for his partner. I mean, your motion right now would just, I think, have John recused on the entire motion, but I can't do that for you. And I'm not even suggesting you do it. I can, see what I can see the other side, but I've got a motion and a second, and we have to be respectful of that, or we have to consider changing the motion before we vote.
Or Walker made the motion and Mark seconded it, but
I'm sorry, I thought it was you.
my 2 cents are let's vote, and if we got 7 votes to send these 3, then let's do it. And if we don't, then we'll figure out another method.
So is that okay with
Yes.
with the 2 that I got that messed up, and I'm sorry, but so let's see. Both so the motion right now is to do Sherwood, Marcus, and Varna. Well, let's see a show of hands and see if we have a majority of the commission that wants to send that slate to the governor. Okay, well, we've got a majority of the commission that wants to send that slate.
Please show me as abstaining.
And John is abstained. Now, honestly, John, just to let me put the foot in the door here, the commission can send up to 5. So I think if you want to make a motion, you can and see where it goes, or somebody can make a motion to adjourn. I'm trying to be respectful to the process here, and it's a little awkward over the TV, but or over the video, but somebody needs to press ahead to see where you want to be here. If you want to cut it off, that's fine.
I would move to include CJ Velez in the slate going to the governor.
Bill?
Yeah, I'm sorry. I gotta, because I'm trying to take these notes. Who initially voted for that 3? I want to make sure I got everybody.
Everybody put your hand up again. We had
I think
everybody in your room, and Ann and Christine and Ralph and Lucy and Rob.
All right, Tim and John did not then.
Yeah, Tim did not. John abstained.
Okay.
And John abstained.
Okay, that's what I needed.
So now I have a motion to add CJ to the list. Do I have a second? Rob, I can't.
I would second John's motion.
Okay, I've got a motion and a second. All in favor, raise your hand to add CJ to the list. 1, 2, 3, 4. So it's gonna, and then all those opposed. Want to make sure. So the motion's going to fail. Do we have any other business to bring up to the commission?
Yes, Your Honor. I would like to make a motion here. I'm gonna move that the certification to Governor Kelly that's required under KSA 20-2909 sub A sub 3 include the following resolution. Resolved that the 25th Judicial District Nominating Commission hereby expresses its disappointment that Governor Kelly did not interview all the nominees this commission when filling the most recent district court judge vacancy. And this commission hereby strongly encourages Governor Kelly to show the courtesy of interviewing all 3 of the nominees being submitted herewith.
I'm going to take that as a motion. Is there a second?
I'd second that.
Ralph is shown as seconding. Any discussion?
Can you not watch YouTube?
What?
Seems to me like all you got to do is watch the replay of YouTube and you've done.
I would prefer that be in writing so the governor could see it and understand how we feel.
Any further discussion? Christine, I saw you moving your lips, but I wasn't sure that you were actually just muted. So do you have something?
I was just talking to Ann.
Okay. Any further discussion? All right, we have a motion with a second. All those in favor, raise your hand so it can be seen. So we're going to have Rob, you're not voting, and everybody else did for those purposes. And Rob, do you want to be shown as opposing?
I do.
Mark, let me ask you this. Would you be okay if we send the 3 names over to the governor right away and send that resolution expressing the commission's feelings to the governor in a separate communication?
I would prefer not. I'd like her to know how we feel.
Let me tell you why I said that, just
sure
to push it. I'd like to get the governor's clock started right away. And it will be, your resolution will be heard, but I would like to start that clock right away because I need to get this judge position filled while Frederick's still around so that we can help with the transition. And so if we wait, then Bill and I kind of have to put together this resolution and get that packaged up. And today is Wednesday, and if we don't get it to the governor by Friday, then we're gonna lose a few days. Is my point.
I don't mind emailing it to you today.
So let's do it this way. Bill, put that together, email it to Shelby and I, and then Shelby, we'll wait to communicate this to the governor tomorrow to deliver those files. Is that okay?
Yes, they're expecting me today, but I can wait till tomorrow if that's what you guys want to do.
I can definitely get it to Shelby or Your Honor here right after we're done.
Well, you're in the office, Shelby. So the question is whether you can put all that together and get it across the street today so that everybody's happy, in effect. Mark gets his motion accompanying with the names, and I get it to the governor, as fast as we can. So can you get that done for us?
Yeah.
Okay. So that solves that problem.
Thanks, Bill.
I'm just happy that Shelby got a battery in that clock. It ran out about 6 months ago, maybe a year ago. So I'm happy about that. Do we have any other business before the commission?
Nope, I'd move to adjourn.
Second, all in favor?
Aye.
Thank you all very much for your time, and we'll get these names to the governor yet today.
Thanks, guys.
Thank you.
Thank you, Al.
Bye-bye.
Shelby, give me a call back when you get settled.
Okay.